bestowed with the gracious presence of Dr. 𝗏𝗂𝗄𝗏 𝗦𝗏, the Vice Chancellor of B.R. Ambedkar Law University, as our honorary guest for inaugural ceremonies of today's national conference. CPJ, welcome you, ma'am. We are also honored with the presence of Dr. Anuj K. Vaksha as our keynote speaker for Technical Session 1, Dr. 𝗂𝗏 𝗏𝗏 as our session chair for Technical Session 1. CPJ feel privileged to have you amongst us today. We are also honored to welcome Dr. Abhishek Jain, General Secretary, Mr. 𝗕𝗏𝗄𝗏 𝗏𝗏 Director General, Dr. Amit Jain, Deputy Director, School of Law, Dr. 𝗕𝗵𝗃𝗃𝗃, Dean, School of Law. On behalf of CPJ College of Higher Studies and School of Law, I would also like to welcome the academicians, research scholars, and students from various universities and colleges who have joined us for the 5th National Conference. I once again welcome you all wholeheartedly. Chandraprabhu Jain College of Higher Studies and School of Law is being promoted by Rishi Aurobindo Educational Society. The college was established in the year 2007, and the School of Law commenced with BLLB program in 2008, and BBLLB course was started from 2014 onwards. We feel pride in saying that since its inception, CPJ College has been striving ahead consistently in all the directions. Keeping tradition of envisioning the intellect in students' knowledge and way of thinking, 5th National Conference of CPJ College of Higher Studies and School of Law is focusing on the theme of family laws, contemporary challenges and solutions. A balanced and a civilized society is an indication of lawful entity, where abiding by the laws is a moral obligation for all. The societal members owe certain rights and duties towards each other. Through sounds simple, but it's not. The debate of rights versus duties initiates a never-ending conflict that can cause disparity in society. In an effort to restore the balance, the significance of family laws can never be overlooked. Thus, the family laws are in practice to ensure and enforce the human rights equally to all the members of society. And our theme for today's conference is also based on the family laws, contemporary challenges and solutions. With this, let's begin with the inaugural of our 5th National Conference. Moving ahead, prayer is a ray of hope which guides us towards the light of success. It is observed to commence any ceremony by invoking the blessings of Lord Almighty. So we would like to start our today's inaugural ceremony with the blessings of Ma Saraswati, the goddess of knowledge and wisdom. For this, may I request Ms. Bhumika to kindly share the performance of Saraswati Vandana by our student Ms. Parul from BA LLB, who has specially dedicated this performance for this inaugural ceremony. Bhumika ma'am, kindly share the video, please.
शिशु है अज्ञानी माता, तिन चरणों का प्यार दे, तेरा पानी तार दे, तार दे, तार दे, माँ सरस्वती शारदे, माँ सरस्वती शारदे।
Thank you, Ms. Bhumika, for sharing the screen, and thank you, Ms. Parul, for such a mesmerizing performance. Moving ahead, I would like to welcome the epitome of CPJ College of Higher Studies and School of Law, Mr. 𝗂𝗚𝗏 𝗏𝗃𝗍𝗏, Director General. Sir is a person with multidimensional skills, a product of Delhi University as he has done his graduation in economics from Hindu College and a postgraduate in economics from prestigious Delhi School of Economics. With the diverse experience of nearly 3 decades, Sir has traveled extensively in India and abroad and has years of corporate exposure with the leading multinational companies. Sir is associated with CPJ College for about 8 years now and is bringing rich laurels to the college in diverse areas. With his support, hard work, motivation, and passion, the college has become one of the leading institutes in Delhi. With its brief, it's my honor to invite the embodiment of college, Mr. 𝗂𝗚𝗏 𝗏𝗏𝗏𝗏, Director General, to kindly give the inaugural address, please. Over to you, sir.
Thank you, Garimaji, and it's the welcome address, not the inaugural address. We have respected Professor Dr. 𝗏𝗂𝗏𝗏𝗏 𝗏 with us, who would be giving the inaugural address, G. And very good morning and to all here, and real welcome to the 5th National Conference of CPJ School of Law. I take this honor to really welcome wholeheartedly Professor 𝗏𝗏𝗏𝗏𝗏 𝗏𝗏𝗏𝗏 for giving her gracious presence on the inaugural ceremony of the conference, along with Professor Dr. 𝗏𝗏𝗏𝗏𝗏𝗏 and Dr. 𝗂𝗏𝗏 𝗏𝗏𝗏𝗏. Thank you so much for being there for the inaugural ceremony. And since Professor 𝗏𝗏𝗏𝗏𝗏 would be giving the inaugural address, and post that the technical session 1 shall commence, in which Dr. 𝗂𝗏𝗏 𝗏𝗏𝗏𝗏 and Dr. 𝗏𝗏𝗏𝗏𝗏 shall be the session chair and the keynote speaker respectively. Thank you so much once again. Giving a little background to today's conference, very frankly speaking, most of you would be aware of the fact that we had our 5th National Conference on the 20th and 21st of March 2020. This was the 5th in a row. Every year we have been having our festival, national festival, law festival of our college by the name 𝗨𝗏𝗄𝗏. And 𝗨𝗏𝗄𝗏 2020 was scheduled for 20th and 21st of March. And it had its 5 events like every year. And National Conference was one of that, in which it would have gone for both the days. Very frankly, everything was being done, everything was being finalized. It was for 20th and 21st, and as all can assume it, from the 13th, the colleges were being closed, the orders of the Delhi government and IP University. And post that from 19th, it was absolutely closed for the faculties and everybody. And after that, we all know the story, how the COVID took over and how it all happened in the last year. We are still not over it. And very looking at it, we had been thinking that, once the offline college resumes, once everybody starts coming, we shall hold the 𝗨𝗏𝗏𝗏𝗏 once over again, which was deferred at that point of time. But looking at it, that it is looking to be not ending that soon, and already a very good time had since elapsed. We thought of starting with one by one all the events of the 𝗨𝗏𝗏𝗏𝗏, and we have commenced 𝗨𝗏𝗏𝗏𝗏𝗏, the events of it with the national conference, which is there today, and we would have the 2 technical sessions after the inaugural session. I must say one thing, at that point of time, every year we have been picking some or the other relevant theme for the conference. And as it was taken at that point of time, and since we had already received papers for presentation, etc., from a very good number of to-be delegates at that point of time, we thought that there's no point that we be changing the theme of the conference and let it remain as it is, as it was scheduled to be there for the March conference in the last year. So like family laws, contemporary issues and challenges is the theme for today. And if I really look at it, I'm not a guy from the law. As Garimaji has just said, I'm hardcore from the economics background. But being in the College of Law and School of Law, as I say, CPJ School of Law, I've also learned law quite a lot along with the students. So looking at as things which go all around, I feel family laws, of course, 𝗏𝗏𝗏𝗏𝗏 ma'am would throw more light on that. But as per me, I feel the very first constituent of anything that could have happened in our, in the mankind history is the constitution of a family. I think the progenies and things that started from there itself, right from the ancestral times, the real ancient time started. So like family, when it looks to it, no two doubts, as a constituent is been, I think so this is the oldest kind of a thing which had existed for years, for thousands of years. And when did the laws come official, where I do always feel that as such there would have been laws, which would have been governing the family of, the yesteryears too, when the official family law would have not been there, but it would have been in some respect or the other, for a family to maintain its decorum, to maintain its other things, and to go on. So I think we would be talking a lot about family laws and related themes, the sub themes of the main theme. And I'm pretty sure of the fact that today's national conference is going to be a real memorable one for all of us. And it's been a great work on behalf of all the faculties and all the coordination committee members of the national conference who have done a great deal. And of course, I must not forget thanking Dr. Abhishek here, Dr. Abhishek Jain, our General Secretary, who has always been looking forward to such academic events and gives all his cooperation and support for these things to become grand success. So with this note, and as I always feel, one more thing to say here, that with the passing of times, things would keep evolving. And like we never had a COVID, now we had the COVID, so that's why we had the COVID vaccine. Had it been last year at this point of time, nobody would have thought there would be something called a COVID vaccine. A vaccine comes once any epidemic comes. So like I feel that no two doubts, once we go through things, laws and other things, they keep evolving as per the changing times, as per the need of the hour. As I can say, in some time, we have international humanitarian laws coming very strong worldwide. It's because of a lot of such happenings which have happened in the world in the recent times. If you look at the complete holocaust of the Yazidis at the hands of the ISIS, or prior to that, the atrocities that the Taliban did in Afghanistan, even much prior to that, what the Nazis did to the Jews, absolute extermination, a Holocaust in the Second World War. I feel post these so many events which happened, even in the latest times, which is just a year or two back, the Yazidi Holocaust. So like we feel that humanitarian laws, the international rights, all these things, they started evolving. And I'm pretty sure of the fact that such things, they would keep coming up. Law is always there to behold the things and to let it go as they should be. And with this note, I once again thank Professor Dr. 𝗏𝗵𝗵𝗏𝗏, Dr. Anuj Baksha, and Dr. 𝗏𝗏 Gautam to be there as our honorary guest and as our guests for the technical conference one. I also welcome all the delegates who are here, who will be presenting their papers. I also welcome all the students and other people who have joined in to witness the goings of the conference and to learn definitely a great deal out of it. Thank you so much, and wishing this conference to be a grand success today. Thank you so much. Over to you, Garima, please.
Thank you, sir, for sharing your valuable insight in today's national conference. As said by Dr. APJ Abdul Kalam, a good teacher can inspire hope and ignite the imagination and instill a love of learning. On this note, it's my honor to invite our honorary guest, Professor Dr. 𝗏𝗏𝗄𝗏 𝗦𝗏𝗃, Vice Chancellor B.R. Ambedkar National Law University, Sonipat. Respected ma'am is having the rich 25 years of experience in academics and research. Her area of research includes women in law, family law, human rights. She is a Commissioner, State Information Commission, Punjab State, and she is also awarded as a postdoctoral fellowship by UGC in August 2009 to July 2011. She is also being awarded as Grade 8 Woman of the Year Award 2020 on 7th March 2020 by 𝗓𝗏 Jan Seva Charitable Trust on International Women's Day at Hindu Girls College, Sonipat. Ma'am has presented and published various research papers in national and international conferences and publications. Students are highly benefited with her expertise in the legal world, and her main vision is student development through legal education in an innovative and intellectual way. Ma'am, CPJ welcome you wholeheartedly. Now, I would like to invite ma'am to kindly address the gathering and give her inaugural address, please. Over to you, Dr. 𝗏𝗏𝗄𝗏. Ma'am, I request you to kindly unmute yourself. Yeah. Welcome, ma'am.
Thank you, thank you. So, the managing director of this prestigious college, Mr. 𝗕𝗏𝗏𝗏, coordinator and co-coordinator along with their organizing team of this webinar on family laws. I first of all congratulate them for choosing such a relevant topic. And this topic is very close to my heart. That's why when some of you called me to be the part of this event, I could not say no. The thing being, whenever I was teaching law, this subject was my favorite. And I used to tell the significance of this law, this paper. And I always suggest that this paper is not just not to pass your semester, because this paper is going to govern you throughout your life. This is the relevance of this law, that whether we want or not want, we are within the ambit of this law, right from the birth till death, even after death. So we are being governed by this law, so we must know what is this law. If we happen to open a company, only then company law will be applicable, right? Or we enter into a contract with other, or we commit a crime, then those laws applies to us. But this law applies to us automatically when we come to this universe. And rather, its implication starts when the child is still in the womb of the mother. But unfortunately, presently, this part of the area has become most neglected. Many universities and colleges, they don't allow post-graduation in this subject. They say this is irrelevant. The focus is on the international law. The focus is on the criminal law. The focus is on the constitutional law. They have their own significance, but this subject is the base of all other laws. Let me tell you. When the child is born, automatically his right for the maintenance, for his parental care starts. Who will be his parents? Who will care after him? Who will give the nourishment and his upbringing? So he come under the fold of Guardianship Act. Automatically. Has no choice to be governed. Again, if the child is given in adoption by the biological parents to the other family, he is implanted in that family and he becomes part of that family, and then the law of adoption comes into the way. So when he grows up, his other rights, right to family and divorce, they also being, because he has to marry or he has to be the part of a family. So then family law in that way come into picture. Then the right within the spouses, husband and wife, automatically he becomes the part. There's no choice at all. So why we should not encourage the students to focus in this part of the area where they have most potential in the practice as well as in the research and furthermore. As we know, what is the purpose of law? The law is to regulate our behavior. Behavior in the family, outside the family, towards spouses, towards other citizens, and whatnot. And so far as family laws are concerned, they govern our behavior within the family towards other relations, to other family members. Now we know that family is the base of the society. And how family is formed? There are certain norms. And these norms are applicable in all civilized societies. So a family starts from a bond between the husband and we call it a marriage. And so far as Indian society is concerned, we have considered as one of the sanskars. So every Hindu or every person who believe in Hindu culture has to perform 16 sanskaras, and marriage is one of them. So we consider it as a duty towards our society, duty towards our ancestors, and duties towards our forefathers. So this is just not a contract, but today's generation consider. That's why this contract can be broken without any second thought. So we must put this idea in the mind of the persons that the family, what is family? Simply living 4 persons in a home does not mean a family. Certain emotions, certain trust and love, that is the basic bond of a family, which is losing because we are passing such laws which are eroding our family relations. Sorry to say. We formed the laws keeping in view the single individual and not family or society at large. We are following the pattern of other societies where the marriage is just a simple contract and it's not a something which we call a sacrament or relation for other family members or a thing by which we are going to be a good citizen or we are producing a good citizen. There was a time when we had a joint family system. 3-4 generations living. It was a insurance for every person who was living in a. If the parents of a child is died due to accident, due to illness, there was nothing to worry who will take care of that child. He had insurance in that joint family that the karta of the family will take care of him. So under the our ancient Dharma Shastra, we don't find the much rules regarding guardianship because karta was the natural guardian after the parents. So he had to look after him. There was nothing to worry if one of the family member loses his occupation because others were to support him. In the old age, we need not to construct old age homes like today's because it was the moral duty of the children to take care of their parents. Because in our culture, we have always emphasized on duties called dharma. We now misunderstood dharma. We have been using this term as a religion. Religion is simply a way of worshipping. My way of worshipping may be different from the others. I may go to temple, may go to a mosque, to a church or to Gurudwara. That is my personal thing. Dharma is what I owe to others, what I practice in my own families and my behavior toward the others. So we have to once again put emphasis on the duties. No one wants to do his duty. Everyone wants rights. This concept of human right is based purely on the concept of rights, individual rights. No one wants to do duty. And you know that those persons who have studied political science, we know rights and duties are correlated. One's right is duty of the other. If I perform my duty as a mother, so my children's rights are automatically granted to them. Now, the thing is, the parents still do their duties, but the children, when they are grown up, they are not such tamed. Maybe there is something lacking in our educational system that they don't realize their duty towards the parents. That now their parents should be brought up by them. They forget what is lacking. Lacking in the system, in the educational system as well, in our laws. In our old ancient laws, it was the primary duty of the child to take care of the parents. Even if he has to do 100 misdeeds, he cannot shun this duty. It's clearly laid down in many Samritis that it is the duty of a man to take care of his moral duty, as well as, because there was law and morality was something same under the ancient period. So there was not much difference between morality and law. So it was the moral duty of every individual to take care of his wife, children, and parents. Even if he had to do 100 misdeeds. Presently, if the parents are not being taken care, he had to go to the court, and court says, you have to first prove that you are not having any income, you are not able to earn, only then we will ask the children to provide you the maintenance. So under such circumstances, every child, because we know man is basically selfish. Every human being is a selfish, and this has been proved by various scholars, Indian or foreign. And the whole process of law is to regulate this behavior, that we are to be tamed. Our behavior has to be tamed. So earlier, the laws were made keeping in view the benefit of the family, benefit of the society. Today, our focus is on the individual. So this joint family broken, this is not one day's task. Continuous efforts were made by the authorities that if we broke the families, if we create disturbance in the family, we can create disturbance in the society, and we can rule for a longer period. And this has been proved by the researchers. Whenever there is any disturbance in the family, it is reflected in the society. In the broken families, or in the families where the parents are estranged to each other, the children may commit crimes. So the data shows that the rate of juveniles is more in those families where there is disturbance in the relations of the parents. Now, I must say that various laws where judicial pronouncement has been made to erode the institution of family, marriage itself. So what is marriage? Marriage is just a formality. And this formality is performed in each and every society. Their norms may be different. The rituals may be different. The ceremonies may be different. So certain norms to regulate the relations of the man and a woman is being practiced. Now the whole process is being done that let us erode the marriage institution itself. We are introducing the concept of living relationship. And the argument is given that even in many tribal areas, it is still prevalent. But mind this, they live in such a relationship because they cannot solemnize marriage. They don't afford the lavish expenses of the marriage, but they just are not living and just not leave each other. They live as a husband and wife and perform all their duties towards their children. If live-in relationship is just for the sort of escapism that we don't want to take the responsibilities of the children, then it is going to be very bad thing in future for the society itself. Because if we say it is a society, there must be certain rules and regulations, and it is the duty of each and every person living in that society to follow those rules and regulations. Otherwise, there is no need to frame the rules, and let's go back to those society where there was no rule. Everyone is free to do whatever he wants to do. Then we can't call that society as a civilized society. If we say we are civilized, we have to behave in a civilized manner. Now we know that we have framed laws just imitating other societies where there are individual families. Let's take the example of Domestic Violence Act, where there is a concept of shared household. What will be the shared household? You know that due to the strange relation, due to the fight between husband and wife, who are the sufferers? The parents, who have nothing to do with this petty things which they are committing, but they are the sufferer. They are put behind the bar. Same is the case of the dowry laws. Dowry laws are so, you can say, misinterpreted, misconceived. The act itself says if you are giving something out of your own choice, it is gift. But if the same thing has been demanded, it becomes dowry. Simply, the mode of giving change the nature of the things. We know that every parent, now every girl wants that she should have all the facilities along with her while going to the husband's place. So, and the parents also, they are bound to give all those facilities. When they could not have the compatibility, then they take the shelter of this law, and this law is being misused. During my research, because it was on the human rights of the prisoners, I visited 13 jails of Punjab myself as a researcher, and I found out so many families languishing in behind the jail just because the relations of the husband and wife were not normal. The parents were living 100 kilometers, still they were trapped in the dowry laws. Our researcher must do research on these areas, that those laws which have become redundant and which are causing trouble to the whole of the society, they have to be scrapped. But we have to come forward. We have to do a serious research on those aspects. Now, in the concept of equality, you know, equality is the birthright. And right from the beginning of this universe, 3 rights, right to freedom, right to equality, right to life, has been there in one form or the other. Now, in the name of equality, we keep on transforming our laws. And instead of going forward, we are moving backward. We have given right to equality to both brother and sister in the property of the parents, right? Earlier, there was such a provision under the Hindu law. I'm much focusing on the Hindu law because there's a majority in India of the Hindus. And we keep on making amendment in the Hindu law for very frequently instead of other personal laws. So India is the only state where the various personal laws are applicable even in the 21st century. On one hand, we are talking about equality, right to equality, but still the discriminatory personal laws are existing in our so-called civilized society. Now, under the Hindu law, we have given equal rights to the both son and daughter. Firstly, it was equality in the self-earned property of the parents, and now it is in the ancestral property too. There was a one provision earlier before passing of these laws that the daughters used to inherit mother's property and sons used to inherit father's property. Their roads were apart. There was no confrontation, no problem at all in the families at all. But now, when we have given equal rights, hardly a single daughter gets her right in the property of the parents. Sorry to say. And no sister want to break up his ties with the brother because he simply says, if you want the share in the parents' family, our relations are cut off from today. So she has to surrender. So in the name of equality, we have taken her rights. Is it not so? That we have once again have to think about that whether our sages were more sensible about the relations, about the families, or we are more sane. Again, I used to study in the family laws the concept of 𝗕𝗵𝗃. Many of us may be ignorant about this fact because it is not being taught today's family law. The eldest child was given double share as compared to the other children. We say it is a discrimination. Every child should be given equal right. Why there was such a provision? Due to that 𝗕𝗵𝗃, the eldest child, because he starts sharing the responsibility of the parents when he grows up, and the parents prefer to live with him. Every relation is coming, sisters coming to the parents, living for weeks together. Nobody has objected. While giving equal rights to all the brother and sister, irrespective of the age, no child is ready to keep the parents with him. The story of Bhagwan is repeated in each and every family today. We have to think about these lines, where we are getting wrong. Because we are being governed by the laws. If there is something which is lacking in the law, we have to reframe them. We have to find the solution. And today we are sitting together to find the solution. And I think we must start from ourselves. We must focus on our duties. There are so many issues which have to be discussed, and I think most of the researchers are going to take up all those issues, whether that issue is of living relationship or the maintenance of the spouses or surrogacy, adoption. And because after passing of the CARA regulations, there's a much difficulty in adopting a child, even if the parties are very genuine. They are facing a lot of problem in adopting a child. So I think I have said enough. So now it is the role of the advocates to save the families, because if the family is saved, then the society will be more progressive. And if there is a problem in the families itself, so we have to relook all those laws which govern the families, and then we can save our fabrics of the society. Thank you everyone for your patient listening. Thanks once again for giving me this opportunity to share my views.
Thank you, ma'am, for sharing your inspirational thoughts on the theme Family Law, Contemporary Challenges and Solutions. With the kind words and the gracious presence of our honorary guest, Dr. 𝗂𝗶𝗃𝗄𝗏 and Dr. 𝗔𝗄𝗏 𝗀𝗏, and our senior dignitaries, Mr. 𝗂𝗏 𝗏𝗃𝗏𝗏, Director General, and Dr. Amit Jain, Deputy Director, School of Law. May I request all the honorary guests and the senior management to formally announce the opening of our 5th National Conference on the theme Family Law, Contemporary Challenges and Solutions by holding the proceedings of the same, please. So I request all the honorary guests and the senior management to kindly hold the proceedings and inaugurate the 5th National Conference of CPJ School of Law, please. So I also request Professor Dr. 𝗂𝗶𝗃𝗄𝗏 to kindly hold the proceedings, please. Thank you, senior management, and thank you, honorary guests. I hope our technical team has already clicked a wonderful photo of yours. Before concluding, I would like to share with you all the schedule of the National Conference, which will be as follows. The conference will have 2 technical sessions. The technical session will take place from 11 a.m. to 1 p.m. And after that, we'll be having the lunch break of 30 minutes. That is from 1 p.m. to 1:30 p.m. After the break, we'll be heading towards the technical session 2, which will take place from 1:30 p.m. to 3:30 p.m. I would also like to inform to all the delegates that we'll be having the valedictory session at 3:30 p.m. in which the best paper award for both the sessions will be announced. So I also invite all the delegates to be a part of valedictory session 2. In the end of the inaugural session, I would like to express my deepest gratitude to Professor Dr. 𝗂𝗶𝗃𝗄𝗏 for giving her valuable time to us. I also would like to thank Dr. 𝗂𝗏 𝗀𝗏, who would be heading the technical session 1. Thank you, ma'am, for your precious time which you have given to CPJ.
Ms. Garima, Professor Dr. Anuj has also joined in, and is very much there, please. Yeah.
Okay. So welcome, Dr. Anuj 𝗏𝗏𝗏, and thank you for being a part of a technical session. In the end, I would also like to thank our senior management for giving the platform to all the researchers to share their studies on the theme of family law. I would also want to request Dr. 𝗂𝗶𝗃𝗄𝗏 ma'am to kindly give the interview bite. For that, one of our resource person will send you the link personally after the inaugural session, please. So thank you, everyone. Hope you all have a nice day ahead. Now we'll be starting with our first technical session. For that, I would like to invite Mr. Vivek Tripathi, Assistant Professor, School of Law, to kindly host the technical session 1, please. And all the best to all the delegates, and thank you, our honorary guest and senior management, for being a part of inaugural session. Thank you, everyone. Over to you, Mr. Vivek.
Thank you so much, Garima ma'am. Good morning, everyone. I, Vivek Tripathi, Assistant Professor, School of Law, welcome you all for the technical session 1 of National Conference on the theme Family Laws, Contemporary Challenges and Solutions. Today, I'm honored to welcome Dr. 𝗂𝗏 𝗀𝗏, Assistant Professor, University School of Law and Legal Studies, Guru Gobind Singh 𝗓𝗏𝗏 University as Chairperson, Dr. Anuj 𝗂𝗏𝗏, Professor, University School of Law and Legal Studies, Guru Gobind Singh 𝗓𝗏𝗏 University, as our keynote speaker. I'm also privileged to welcome Mr. 𝗂𝗏𝗏𝗏𝗏, Director General, Dr. Amit Jain, Deputy Director, School of Law, We are privileged to have you all with us as part of our first technical session on family laws, contemporary challenges and solutions. To begin our technical session, I would like to invite epitome of CPJ College of Higher Studies, Mr. 𝗔𝗺𝗀𝗏 Director General. Sir is a person with multi-dimensional skills, a product of Delhi University, as he has done his graduation in economics from Hindu College and a postgraduate in economics from prestigious Delhi School of Economics. Sir is associated with CPJ College for about 8 years now and is bringing rich laurels to the college in diverse areas. With his support, hard work, motivation, and passion, the college has becoming one of the leading institutes in Delhi. With this brief, it's my honor to invite Embodiment of College, Mr. 𝗔𝗺𝗀𝗏, Director General, to give the inaugural address and welcome our keynote speaker and session chair on behalf of CPJ College of Higher Studies and School of Law. Sir, over to you.
Thank you, Mr. Vivek, and good morning once again to all of you. Am I hearable, Mr. Vivek?
Yes, sir. Yes, sir. Very much.
Thank you so much. Welcome, Professor Dr. Anuj Vaksha. Nice to you being here, absolutely. And Dr. 𝗏𝗏, thank you for making it and being a part of the conference, please. I wholeheartedly welcome you both, as Professor Anuj would be the keynote speaker of Technical Session 1, which is soon going to be commencing. And Dr. 𝗏𝗏, since you would be the, you'll chair the session. So I'm pretty sure the participants, the delegates who are going to be presenting their papers in the Technical Session 1 are going to give a good feel to the conference by sharing their views and thoughts. And I'm pretty sure that this would go a long way in learning for all of us. Professor Dr. Vinay K. Mehra has already expressed a lot on family laws. Even it was certain things which was coming, I was hearing to her very impeccably. And no two doubts, it's always a learning when you hear anybody learned in some respective field of theirs. And it was definitely a learning for me too. I did come to know some more things about the family law and the family as a concept by itself. And I'm pretty sure this Technical Session 1, the papers that would be given by the delegates who are here is definitely going to be adding more knowledge and more wisdom to all of us on different themes that they would have chosen for their respective papers. So looking best for the Technical Session 1, and may I request here itself to Professor Anuj and Dr. 𝗏𝗏 that once the technical session is over and the Technical Session 2 starts, wherein we have Dr. Rakesh and we have Dr. Kamaldeep Singh from IP University being the keynote speaker and the session chair for the Technical Session 2. But once it closes down at 3:30, I would request both of you to be a part of the valedictory once again, please. Yeah. Thank you so much. And over to Mr. Vivek and for the proceedings of the Technical Session 1 to commence. Thank you so much.
Thank you, sir, for sharing your words of wisdom. We are honored with the presence of Dr. Anuj K. Vaksha, Professor, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, as our keynote speaker for Technical Session 1. Sir is presently Professor of Law at Guru Gobind Singh Indraprastha University. He has been working with Guru Gobind Singh Indraprastha University since 2002. Before joining Guru Gobind Singh Indraprastha University, Sir has worked with South Asia Regional Delegation of International Committee of Red Cross. His research and technical areas involve international investment law, jurisprudence, judicial process, international humanitarian law, and disaster management law. Sir has recently published a book titled Governance of Foreign Investment in India, Defining Perspectives. Sir, CPJ welcomes you wholeheartedly. Now may I request Dr. Anuj K. Vaksha to kindly give the opening remarks of first technical session. Sir, over to you. Dr. Anuj K. Vaksha. Sir, it's a request, please unmute yourself. Sir, you are co-host.
Am I audible?
Absolutely,
Yes, sir,
Dr. Anuj, absolutely fine.
Thank you so much, Professor Vivek Tripathi ji. And thank you, 𝗔𝗺𝗀𝗏 𝗏, my very say good friend, and thank you other participants. I say rather I find my worthy colleague Dr. 𝗲𝗄𝗏 𝗏, Dr. Rakesh here, and others teachers here. I say again thank them and thank everybody present here for giving me this opportunity to speak on the occasion on an extremely say challenging issue on the say issue of family law, contemporary challenges and solutions. I'm sure the participants would be giving their perspectives on the issue. Family law, I have not been so privileged to be reading family law except as a student when I was doing my LLB. Nonetheless, it would be wrong to say that we do not understand the implications of the family law. I, as a teacher of jurisprudence, and I, as a teacher who had the opportunity to teach global justice, globalization, so many factors, I see family as a unit of everything of the society that we see around. So society, right from organized as it is, whether at the level of the state, whether at the level of an international community, the problems that one conceptually finds, the origin of those problems or even solution of those problems you will find related to the family. One of the issues I was just wondering how many of you have may have taken note of a term which is there in the preamble to the Constitution, fraternity. So fraternity in a very layman's sense would possibly mean having a concern, having a feeling of say fellowship for the fellow human being. When we talk of justice or say global justice or justice at any level, whether institutional justice, legal justice, family level justice, one question comes, why should we just at all? Why should I need to be fair or I need to be nice? Law is a tool to the process to attainment of justice. And whosoever is connected with law would at some stage ask the question, why should there be justice all around at every level, so on and so forth? There can be a number of justification and answers to this question. Why should one be just? One should be nice. One should be fair. One answer which I find it actually comes from the family, and it is that if my parents were not just to us, or everyone's parents were not just to us, possibly we would not have reached the place where we are in or wherever capacity we are. It is from the family that we get that sense of having a unit of togetherness. So family consists of a couple of members, all of us caring about each other, all of us need to love each other, all of us need to be nice to each other, all of us should be good to each other, so on and so forth. It is, and my best compliments to all the organizers, and my special thanks to the CPJ administration, particularly my worthy friend 𝗙𝗂𝗏 𝗏 and my other colleagues here sitting. Thank you so much. Thank you so much for giving this opportunity. Thank you.
Thank you so much. Yeah.
Thank you so much, sir.
Thanks.
Thank you so much, sir, for sharing your valuable insight on the theme Family Law, Contemporary Challenges and Solutions. Now, let me start with paper presentation for the technical session 1. I would request the speakers to please limit their respective presentations to maximum 10 minutes. All the presenters are requested to kindly take note of it. Let me invite our first paper presenter, Professor Dr. Komal 𝗲𝗏 𝗏 along with Nikita 𝗲𝗏 𝗏. And the title of their paper is Uniform Civil Code and Gender Justice, A Quest for Equity.
I would request Mr. Vivek to kindly give a very brief introduction of the presenter, please.
Okay, sure, sir. Dr. 𝗂𝗏𝗄𝗏𝗀𝗃 is Assistant Director, Seedling School of Law and Governance. She is from Jaipur. Dr. 𝗂𝗏𝗄𝗏𝗀𝗃. Along with Nikita 𝗂𝗏𝗀𝗃. Ma'am, please unmute yourself.
Hello, good morning, everyone, and thank you so much for having me here. I'm Nikita 𝗂𝗏𝗀𝗃. I'm Assistant Professor in Maytree College, University of Delhi. Dr. 𝗂𝗏𝗄𝗏𝗀 has not been able to join us, and there's a very slight request which I have from all of you. If it's not a problem, can I keep my camera off, because we're actually experiencing slight internet issues. And given the time constraint, then I'd be able to wrap up my paper within the stipulated 10 minutes. I hope that's not inconvenient for everyone here.
No worries.
I would suggest, Ms. Nikita, you may continue with the video remaining on, and in case you encounter any problem, you can then switch it off, please.
Should I start?
Please.
All right. I will be essentially reading out the main points from the paper, and the whole idea, since I'm a teacher of political science, I have tried to engage with it from the point of view of the general legality, legal pluralism, which is there within personal laws, and how the judiciary fits into this from the point of view of the main judgments that they've given on the question of uniform civil code. Now, the makers of the Indian Constitution strove to establish an egalitarian society. All of us here are familiar with Articles 14 and Article 15 of the Indian Constitution. They're considered to be the bedrock of the Constitution. And they provide that all people in India are equal before the law. They have equal protection of laws. But most important, citizens should not be discriminated against each other on the grounds of religion, race, caste, gender, or place of birth. The state also has the power in India to make special provisions for the protection and empowerment of women, for the protection of children. And all of these principles, the relevant articles of the Constitution, they gave shape to what we know as Article 44, that envisaged the Uniform Civil Code in personal laws. We know that because of plurality of religion and very specific nature of colonial administration, there is plurality in personal laws in our country amongst different religious communities. And it is perceived, it's also true, that personal laws in varying forms are prejudiced against women vis-a-vis the men. The UCC, therefore, is piped to be an effective device for gender justice through the administration of secular civil laws. So we see that how the question of uniform civil code is important from the lens of both secularism as well as gender justice. UCC itself, that's the short for Uniform Civil Code that I'll be using throughout the paper. It has always been under a fog of perplexity since the time it was first debated in the Constituent Assembly. Various objections were raised by Hindu and Muslim members of the Constituent Assembly, and various leaders of repute like 𝗏𝗏𝗄𝗏𝗏 Beg, Muhammad Ismail Sahib, B. Pocker, etc., they all argued that personal laws related to issues of marriages and inheritance had religious backing, had religious origin. In case of, for instance, Muslim personal laws, they originated from the Holy Quran and Sharia, and therefore they needed to be kept outside of the ambit of any civil code that was being envisaged. On the other hand, Dr. B.R. Ambedkar, Dr. K.M. Munshi, they took a different stand. Dr. Ambedkar contended that India had attained commonality in criminal code, but the diversity in civil law was such that it was in complete violation of the fundamental rights. precisely because it discriminated between men and women, and accordingly, there could not be any place for it in independent India. As the debates of the Constituent Assembly revealed, the Uniform Civil Code was actually initially proposed for national integrity, but the members of the Constituent Assembly thought that it would be better to go ahead with the proposal as a suggestion, as a guideline under directive principles of state policy, because they were not sure if as a law in that very moment, it would be viable for a conventionally heterogeneous society like India. Now, it's really important to understand that from the debates in the Constituent Assembly, and given the very low participation of women in the Constituent Assembly debates, I'm sure all of you must be aware here that we only had 15 women in the Constituent Assembly of India that led to the foundation of the drafting of the Constitution. It's imperative to understand that the main voice of concern came from the perspective of national integration. It came from the perspective of the rights of certain men being violated of certain religions as against rights of men of other religions. And then, of course, there was the question of whether you should have plurality when there is already uniformity, commonality in criminal code, and what could be the, of course, like given the whole gamut of problems and clashing perspectives, of course, the judiciary had to confront many complex challenges. I will be going through notable cases. So for instance, State of Bombay versus 𝗏 where the judiciary held the constitutional validity of the Bombay Prevention of Hindu Bigamous Marriages Act, 1946. It was challenged basically. And it was challenged on the grounds that it was applicable only to the Hindus, whereas the Muslims, and Muslim men specifically, were given the full freedom to contract more than one marriage. Now, this was argued to be on the ground of, to be in violation of Articles 14 and 15 of the Constitution. Now, the court decided to uphold the validity of the Prevention of Hindu Bigamous Marriages Act. This is all happening in the absence of course, UCC. And while upholding the validity of the act, the judgment argued that Islam and Hinduism were different faiths that had different historical background, cultural stance towards life, and towards other aspects. And most important, the judgment mentioned that prohibition cannot be tested only on the anvil of religious discrimination. So we see basically that there is an attempt by the judiciary to fuse in through a very top-down approach the understanding of looking at the question of UCC from a lens other than that of religious discrimination, national integration. And perhaps we need to be, we can argue that it's because of various progressive judgments of the judiciary, never mind the top-down approach, that the element of gender justice, while talking about UCC, seeped into the common political and the legal discourse. Now, the validity of the Madras Prohibition of Bigamy Act was upheld by Madras High Court as well in Srinivas Iyer versus Saraswati Ammal on similar grounds. At the same time, the efforts by the legislature to bring social change could have been rendered unconstitutional, Article 15, but were instead held by the courts to be non-discriminatory in nature through the adoption of extra-religious approach. Personal laws were also not included in the definition of law under Article 13, and that has allowed various creative interpretations to be used in this case. In the case of inheritance, succession, rights around that with regard to personal laws. Now, it's important to note that it's against this background, basically. You've also had the 𝗏𝗏 case, I might be mispronouncing, where the Supreme Court interpreted Section 14 of the Hindu Succession Act, 1956, and transformed women's limited ownership of property into full ownership. So we see essentially that the judiciary is constantly trying to adopt a supportive approach to infuse the element of gender discrimination. I'll take 5 more minutes.
Okay.
5 more
Sorry
minutes.
to interrupt. Okay, thank you.
I'll just quickly come into and skip the details. So we are all aware about the 𝗏𝗏 case, where essentially the court held that a Muslim woman was entitled to get maintenance beyond the period of iddat, and Section 125 of the CRPC was introduced. Even though you had Muslim Women Protection of Rights on Divorce Act enacted in 1986 to invalidate the judgment pronounced, we again see that in the subsequent Daniel Latif's case, the Supreme Court upheld the act valid, but interpreted Section 3 of the act to rule that a Muslim husband is liable to maintain the divorced wife even after the iddat period. You've also had other epoch-making judgments of the Supreme Court in 𝗟𝗏 𝗏𝗀𝗃 and Lily Thomas cases. Not going to get into the details, but it needs to remember that it is here again, both in case of Banu Begum as well as in cases of 𝗟𝗏 𝗏𝗃, Lily Thomas, that the question of giving a fresh look to Uniform Civil Code under Article 44 came into existence. We know very well that most of the personal laws discriminate against women, specifically when it comes to inheritance of property. We know that in the case of Muslim wife in particular, there are various discriminatory practices in personal law. So for instance, you have polygamy, whereas wives do not have the same option. Men can legally, under the personal law, Muslim personal law, keep 4 wives at a time. Similarly, the status of women is considered inferior in the realm of customary divorce, as well as in the case of other types of divorce. Husband can declare unilateral divorce, but the wife, if she wants to remarry the same husband, must go through a very patriarchal practice of halal. Husband's consent is very important in various kinds of divorce. And there is this whole contention still as to what should be the period of maintenance by the divorced wife. We know very well that the practice of triple talaq, which was declared unconstitutional recently by the Supreme Court, was lauded by all. And it's basically in this background that we see again the clamor for UCC emerging. This is just essentially a historical framework where I've tried to show that one needs to locate the judiciary in terms of the perspective of gender discrimination and gender empowerment that they've been able to pronounce with matters related to personal laws, because when it comes to political discourse, it's primarily been pegged along the lines of national integration and religious and discrimination of the man under various personal laws. The fact that, let's say, for instance, Hindu man cannot have 4 wives, cannot have a second wife, but a Muslim man can. It is the judiciary essentially that includes, that introduces the lens of gender empowerment. However, there are certain myths around personal laws which I want to address, which I guess often gets reduced or sort of shunned away. There is this myth that you have uniformity in criminal laws, because it's a fact that different states, for instance, have different procedures, different laws with regard to anticipatory bill. Faizan Mustafa has talked about it, for instance, in detail. Similarly, too, Hindus too are not governed by homogeneous laws, even after the enactment of the Hindu Code Bill, as is commonly believed. So, for instance, in Goa, Hindus are still governed by the Portuguese family and succession laws. Muslims there are governed by the Portuguese and Shastric Hindu laws and not by Muslim personal laws. The Hindu Code Bill also recognizes customs of different Hindu communities. So while marriage amongst relatives is prohibited under Hindu Marriage Act 1955, it is considered auspicious in the South. The Hindu Succession Act also makes several compromises. And it needs to be understood, and this is very important, that while talking about gender and social justice through the Uniform Civil Code, we do not make the fallacy of assuming that one religion, Muslim, specifically Islam over here, has not been able to annihilate structural patriarchy, whereas other has been able to. With regard to the amendment that was made in 2005, and which has been spoken of here as well, about the share of the equal share, the daughter being recognized as a co-parsoner in the ancestral property, it's important to understand that testamentary rights are not spoken about still. And most important, the status of the wife. The status of the Hindu wife actually still continues to be subordinate. And she cannot be recognized, so for instance, as a parsoner, as a co-parsoner. Not only that, if a couple does not have a child, the property of not only the husband, but also the wife, both husbands pay. So we see that source of acquisition, the source of acquisition, even in the case of the Hindu personal laws, determine the order of acquisition, the source of acquisition determine the order of succession in case of the Hindu woman even today. You need to also understand that property devolves first to class 1 heir, and if there's no class 1 heir, only then does it go to class 2 heirs. While heirs of sons are class 1 heirs, those of daughters are not. Even among class 2 heirs, preference is given to the male line. In light of the above arguments, it is important to stress, very importantly, that one needs to maintain a holistic image when one is proceeding forward with debates, therefore, on the Uniform Civil Code. The Law Commission of India, for instance, very recently actually said that it is neither feasible nor necessary to implement the Uniform Civil Code at this stage, given the fact that there is still a lot of plurality, and the fact that there exist different kinds of discriminations depending upon how you're viewing women. So woman as a daughter, her status might have been elevated when you're looking at the Hindu personal laws, but not so much when you're looking at the status of a woman as a wife with regard to the Hindu personal laws. Then again, there is this operational cost of implementation of the Uniform Civil Code that has not been dealt into. I would just like to end by saying that it is extremely important to bring about equity in the principles governing inheritance and property rights, as well as maintenance rights of women, irrespective of her role within the family, across all religious communities. We cannot let women of this country to be controlled by feudal and patriarchal society, and the final aim should be able to adopt a principle that truly respects the spirit of the preamble of the Constitution. Thank you.
Thank you so much, ma'am, for sharing your reflective knowledge with us. Now I'd like to invite our next presenter, Dr. Rajesh Patil from Dr. 𝗔𝗃 𝗏 College of Law, Amravati, Maharashtra. And title of his paper is The Changing Paradigm of Law of Maintenance in India. Sir, it's a request, kindly stick to your time limit. Dr. Rajesh Patil.
Okay. Yes. Good morning, everyone. Am I audible?
Yes, sir, you're audible. Can you switch on your camera?
Yes. Can I share my presentation?
Yes, sir, you can. But we would like to see you as well.
Hello. Am I audible?
Yes, sir, you are audible.
Okay. Good morning, everyone. The topic of my presentation is the changing paradigm of law of maintenance in India.
Sir, but your PPT is not visible properly. It's partially visible.
Yes, sir, it is partially visible. Sir, if you're comfortable, you can present without PPT.
Vivek, till the time you can go with next participant, please.
Sure. So by the time we'll take another participant, and Dr. Patil will come later. So our next presenter is Ms. Ghazala Abidin from University School of Law and Legal Studies, Guru Gobind Singh University. And title of her paper is Hindu Undivided Family as a Taxable Entity, a Critical Analysis. Ms. Ghazala Abidin.
Yes, sir.
Please press F5 or it is in slideshow mode.
Yes, sir. Just a second, sir.
Dr. Rajesh, can you stop your PPT sharing? We have Ms. Ghazala Abidin right now, and after her, you can present your PPT.
Hello.
Yes, sir, can you stop your PPT sharing? We have Ghazala present right now, Ms. Ghazala, and after her, you can present your paper.
Okay.
Ma'am, please continue.
Yes, sir. I'm just sharing a screen. Just a second, sir.
Yeah, sure.
Is the screen visible?
Yes, ma'am, it is visible.
Okay. Okay, just a second. Okay. My name is Ghazala Abidin, and I am a PhD scholar at University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. And I shall be talking about Hindu undivided family as a taxable entity, a critical analysis. So beginning with the introduction, I would like to say that the institution of HUF has been prevalent since decades as a medium for holding family property and making family investments. The HUF continues to have its significance in any family's financial planning. It is a well-known fact that the HUFs are considered as distinct persons for income tax purpose and accordingly are also eligible for distinct advantages such as basic tax exemption slab, deductions under the Income Tax Act of 1961. However, huge tax exemption benefits provided too and enjoyed by the members of HUF are being misused by its members for the purpose of tax avoidance. The Hindu laws of succession and inheritance, when combined together, provides great opportunities to HUFs to avoid payment of taxes. Now, keeping this in view, the objectives of my study would be number one, to discuss the growth of HUF and its treatment for taxation purposes. The second objective of my study would be to study and examine as to how HUF is used as a colorable mechanism for tax avoidance. The third objective would be to analyze the reports and recommendations of various committees. And lastly, to suggest various measures for eradicating the practice of tax avoidance by the Hindu undivided family. Now, the hypothesis of my research is that HUF, that is the Hindu undivided family, is used as a colorable mechanism for tax avoidance, thereby leading to the loss of government revenue. It is therefore essential to adopt more resilient or more strong taxation system to curb the practice of tax avoidance by HUF. Now, talking about the HUF model, I would like to say that the definition of Hindu undivided family is not provided under the taxation laws. The Act treats HUF as a person in accordance with Section 2 Clause 31 of the Act, which means that whatever benefits are applicable to a person under the taxation laws, the same benefits are applicable to the HUF under the taxation laws under the Income Tax Act of 1961. So, as per Hindu law, HUF actually comprises of a family unit consisting of members who attain an interest in joint family property by birth. Also, like we all know that in the year 2005, there was an amendment in the Hindu Succession Act. So according to that, under that amendment, what happened was that the the girl child was given the equal share. The females were given equal share in the family property, right? So as per the Hindu Succession Amendment Act of 2005, just like son, even daughters can now be the co-pastor of HUF. So she remains a co-pastor of her father's HUF after her wedding, and at the same time becomes a member of her husband's HUF as well. So a person acquires a membership of HUF from his or her status in the family and not by virtue of a mere contract. This is very important. So the formation of HUF automatically takes place when a member of HUF obtains ancestral property from the ancestor 3 degrees above him. It is also pertinent to mention that there must be at least 2 members in a family to constitute Hindu undivided family, out of which one should be a male member. Now, there are certain taxation benefits that are granted to the Hindu undivided family under the taxation laws. So, under the Act, which means under the Income Tax Act of 1961, HUF has been conferred with certain exemptions. So, these exemptions to a certain extent are similar to that of an individual, like I just said. The Act specifies certain categories of payments and transactions which, if made by the individual, will prove to be beneficial for them in the tax assessment. So same benefit is enjoyed by the HUF if it pays any sum as premium on life insurance of its members. The members of HUF are authorized to claim deduction of said amount under Section 80 Clause C of the Act. So 80 Clause C of the Act talks about deduction on investments. HUF can even make investments in fixed deposits and various other saving schemes. So these transactions can be done in the name of the head of the family, that is the Karta, member or co-pastor of HUF. Now, again, concerned individual has a right to claim deduction under Section 80 Clause C of the Income Tax Act. So in addition to this, deduction can even be claimed on the sum deposited on the PPF account. PPF is Public Provident Fund account of the individual member of the HUF. Now, other benefits available to HUF are that it can also claim deduction on health insurance premium, contribution in the form of contribution in the form of donations to charitable institutions or some other funds, then maintenance of dependent, including medical treatment of a disabled person. The most important part of my research is that my research actually focuses on as to how Hindu undivided family is used as a colorable mechanism for tax avoidance purposes. So the ways in which the institution of HUF has been misused by its members for the purpose of tax avoidance are enumerated under 3 heads. The first one is intersection between succession and inheritance laws. Now, when the inheritance laws are combined with the laws of succession, they together provide various avenues for the HUF to avoid payment of income tax. Now, the HUF makes use of the laws of succession and the property rights to claim exemptions and transfers with a view to trim down the liability to pay taxes either partially or completely. So these aspects provide huge benefit to the HUF, and individual taxpayer is treated unequally under the law. Now, coming to the second aspect, second one is the partial partition. Now, in partial partition, the division and subdivision of HUF takes place. So they are divided into smaller units of HUFs. In addition to the main HUF, each smaller unit of HUF becomes a separate taxable entity. So each unit now becomes entitled to claim separate benefit of exemption limit under the law. Now, income also gets divided into several parts. So partition places each smaller unit of HUF into lower income tax brackets, thereby entitling them to pay taxes at a very, very lower rate. The third aspect is the preferential treatment that is provided to HUF. Now, preferential treatment is given to Hindu undivided families under the taxation laws. Now, this special recognition which is granted to HUF is against the spirit of Indian Constitution. Now, specifically recognizing and treating HUF as a separate taxable entity hampers the fundamental object of secularism. The subsistence of HUF and the advanced treatment of assessment of tax liabilities are not in accordance with the secular spirit which is there in the Constitution of India. In fact, preferential treatment accorded to HUF for tax assessment purposes complicates the collection and assessment of income tax. So this is how HUF is HUF is misused. It is basically misused or used as a colorable mechanism for the purpose of avoiding payment of taxes. So there are various reports and recommendations by various committees. So in the year 1936, the inquiry report on income tax advised that special grant of exemptions to the HUF would lead to substantial revenue loss. Then after that, in 1953 to 54, Inquiry Commission also noticed various inconsistencies in the tax treatment of HUF. Thereafter, 1967, there was a final report on rationalization and simplification of tax structure that also specifically mentioned about the use of HUF as a way of diminishing the liability to pay taxes. Also in 1971, the Wanku Committee it is the first ever official expert body that recognized serious tax avoidance implications of the HUF provisions of the taxation laws. Then in the year 2016, reference was also made by the Ministry of Law and Justice to the Law Commission of India for examining the matters pertaining to the Uniform Civil Code. Then thereafter, in the year 2018, the Law Commission specifically mentioned in its report that the HUF was accorded a special status only for taxation purposes. But special status, it specifically mentioned that the special status is now being misused only for the tax evasion purposes. Finally, I would like to conclude by saying that in the current globalization era, it has become a common practice of moving abroad for carrying business and profession and taking up employment worldwide. The old institution of HUF is vanishing away. Now, provisions under the Act are being merely used by HUF as a device for tax avoidance. Thus, the sanctity of the HUF has been lost, and it is the need of the hour to review the continuance of its special status under the Act. The acceptance and recognition of HUF as an independent taxable entity provides several advantages. But it must not be forgotten that these advantages at the same time threatens the overall object of equity and stability. Using the exemptions applicable to HUF intelligently causes enormous loss to the government revenue. It has been witnessed that the Indian economy is also in the worst situation and is facing problem of low tax collections and fiscal deficit. So the continued recognition of HUF is one of the factors responsible for the erosion of tax base. The solution to tax avoidance problem lies clearly in a simple and straightforward step, whereby the present recognition of the HUF as a separate unit of assessment is totally withdrawn, and all the members are, as a consequence, obliged to report their share of the HUF income or wealth as a part of the total income or wealth for the purpose of taxation. Lastly, I would like to say that the distinct treatment should not be accorded to HUF. Some aspects should be overlooked for the purpose of tax assessment. Then taking immediate action against the problem of tax avoidance by HUF is a pressing need of the hour. Opening the economy with more liberal tax assessment policies will lead to declining the need to avoid tax. In fact, reformation in the personal income tax is also pending. So India must adopt methods and policies, thereby seeking to achieve a balance between equity and efficiency. So more resilient and a more strong taxation system should be adopted for the purpose of curbing the tax avoidance practices by the Hindu undivided family. Thank you so much.
Thank you so much, ma'am, for sharing your research with all of us. If judges want to ask any question from Ms. Ghazala Abidin, they can ask.
I think let the audience start, ask in the end. No, we'll keep the question answer session for how convincingly they can answer the questions raised by the other participants. I think that would be Professor Anuj. Vivek, will that be fine if we put the question answer session in the end?
Sure, ma'am. Sure, ma'am.
So the others can also ask.
Okay. Thank you so much, ma'am. Thank you, Ms. Ghazala Abidin, for sharing your research with all of us. Now, I invite our next presenter, Dr. Rajesh Patil from Dr. 𝗔𝗄𝗃 𝗏 College of Law, Amravati, Maharashtra. And title of his paper is The Changing Paradigm of Law of Maintenance in India. Dr. Rajesh Patil.
Yes, sir.
Please start your presentation.
Yes. Yes, sir. Am I audible?
Yes, sir, you're audible.
Sir, kindly turn on your video.
Sir, kindly turn on your video.
Turn on your video.
Sir, there is some network issue. We are unable to hear you.
Visible now?
Sir, we cannot hear you.
Yes. Am I audible?
No, sir, you are not at all audible. By the time Dr. Rajesh Patil, I think he is having some network issues, so we can go to another presenter. And now I would like to invite Ms. 𝗏𝗏𝗃𝗏, research scholar, Guru Gobind Singh 𝗓𝗏 University, to present her paper titled Emancipation of Women for Dowry Legal Strategies and Emerging Challenges. Ms. 𝗏𝗏𝗃𝗏.
Good morning, everyone. Yes, sir. Am I audible?
Yes, ma'am, you are audible.
Okay, so I would like to present on the topic of emancipation of women from dowry. And this paper has been authored by Dr. Rakesh Kumar, Associate Professor of US LLS, GGSIP, and it is co-authored by me, 𝗏𝗏𝗃𝗏, Research Scholar, US LLS. Women in Indian social setup have been victims of exploitation, torture, and humiliation since long time. The existing social setup, ideologies, and outdated customary practices have been used to contribute to inflict harassment. Among the innumerable social evils, such as child marriage, sati, female infanticide, widowhood, to which the Indian women have been subjected for so long, the dowry death, cruelty by husband and his relatives, and incidents of bride burning have indeed become a matter of great concern for parents, legislators, judiciary, and society as a whole. In India, different kind of people have their own vision for seeing the dowry. As for a business-minded person, it is a net market value or price of the bridegroom. For a practical person, it is the cost of growing up and educating the bridegroom, which was incurred by the parents. For an orthodox person, it is a great mechanism devised by Indian society to help newlyweds to set up their new home. And for a ethical theorist, it's a gift which is given by the bride parents out of their own wish and emotions. But in reality, it is an utterly discriminatory social practice, grossly undermining so-called gender equality in society. It is widely prevailing because no one wants to let it go when it is his chance, and no one wants to risk their daughter's future family life, usually wants it to let it go. Then the family of the bridegroom takes dowry in the form of stridan, but actually it is too different from each other. It is not easy to define dowry as it does not refer to cash and material goods alone. It has been defined as a share of daughter or a sister in parental property given to her at the time of her marriage. But dowry is not really given as amount equivalent to daughter's share vis-a-vis her brothers. Even if there is no substantial family property to be shared, there is tendency among people to borrow money to meet the expenses of marriage and dowry. The number of people in the marriage party, or barat we can say, the number and quality of meals which is presented to them are all the part of marriage deal along with dowry. Thus dowry is not simply the giving away of cash and material goods. Another view which can be taken is dowry is a gift. It is a token of love which is given to one's daughter or sister at the time of her marriage. It keeps her attached to the parent's family even after the marriage. It has become customary to give dowry. Marriage without dowry has become almost unthinkable. In southern India, it is called Sridhanam. In northern India, it is a gift or 𝗓𝗗𝗄 we can say. So whatever conception or name is given to dowry, it is certain that dowry is not the right of a girl who leaves her parents' house after getting married, but it is also a fact that since a girl joins her husband's house in Hindu patriarchal society, she is given due compensation in the form of dowry. It is a gift, it is a dan. Even a girl is given as a dan, which is, we can say, like kanya dan. So this clearly shows a picture of a transition from bride price to dowry. Bride price and dowry may be seen as contrary to each other so far as the direction of gift giving is concerned. Bride price may be defined as transmission of goods, expensive and valuable articles from the kin of the groom to the kin of the bride, in return for which certain rights of the brides are transferred. So bride price may be seen as economic compensation to the bride family for loss of her labor, and bride wealth received by the father or brother of the girl is used to get wife for her brothers. On the other hand, dowry implied ritual and secular transfer of gift from the family of the bride to that of the groom. The quantum of dowry depends on many factors, such as caste, occupation, educational status, as well as prestigious status of bridegroom family. But dowry cannot be termed as groom price because it does not fetch a groom in the same sense in which bride price fetches a bride. Strictly speaking, dowry is stridan property which belongs to women and it cannot be disposed of by a husband or family members. Now, the Code of Manu unequivocally state no father can take even the smallest gratuity for his daughter. For a man, through avarice takes a gratuity, is a seller of his offspring. The recommended act was kanyadan, or the gift of the virgin daughter, whereas the bride price was seen as a sale of a daughter for profit and regarded as shameful. Marriage with dowry was considered mere prestigious and was recommended for higher caste people. Now, this is the magnitude of the problem. The meanness of dowry has acquired such magnitude that now birth of a girl child in the family is considered to be a curse. Bride has to bear physical as well as mental torture. Though the practice of dowry has been banned by the Dowry Prohibition Act 1961, but in reality, this problem do exist. The magnitude of the problem may be simply ascertained from the number of cases which are related to dowry. This data has been taken from National Crime Record Bureau, Ministry of Home Affairs. Now, in 2004, the cases which were registered under dowry death under Section 304B were 7,026 approximately. And under Dowry Prohibition Act 1961, there were 3,592. And under the cruelty by husband and their relatives, 58,121. And till now, this data is of 2018 year, 7,166 the cases were registered under dowry death under Section 304B. And cases which were registered under Dowry Prohibition Act 1961 were 12,826. And so is the case with the cruelty by husband and their relatives, 1,03,272. This is the magnitude of the problem. Let us move on to the legislative approach and judicial responses in addressing this alarming condition. Despite of the initiatives taken by the social reformers in the 19th and early 20th century against the dowry system, The previous system of dowry led to alarming number of suicidal and dowry deaths by young brides. Even the social reformers like Raja Ram Mohan Roy, Rana De, Ishwar Chandra Vidyasagar, Mahatma Gandhi, and many others of 19th and early 20th century have striven hard and dedicated their lives for the abolition of various social evils, including the evils of dowry, from which the Indian women were suffering. The fruitful results of efforts of social reformers were perceived to some extent even long before India gained independence. First of all, in the area of Sindh, even before the independence, the government of Sindh enacted Sindh Deti Leti Act 1939, which was followed by Bihar Dowry Restraint Act 1950 and Andhra Pradesh Dowry Prohibition Act 1958 to deal effectively with the evils of dowry system. To curb the menace of dowry demand, the government of India enacted the Dowry Prohibition Act 1961. In the case of Pratibha Rao versus Suraj Kumar, it was held that it cannot be said that upon a woman entering in matrimonial home, the ownership of Stridhan property becomes joint with the husband or his relatives. Now here in this case, Justice Vardarajan, in his dissenting opinion, however, held that there has to be a specific separate agreement which is indicating entrustment of such property to husband or to her close relations. Now, in absence of such separate agreement for specific entrustment, it would not be possible to draw an inference of entrustment of custody or dominion over the property of one spouse to the other and his or her relations, so as to abstract the stringent provision of IPC. Otherwise, there would be disastrous effects and consequences on the peace and harmony which ought to prevail in matrimonial home. In spite of such noble and deterrent provisions under Dowry Prohibition Act 1961, the menace of dowry could not be controlled over the years. In fact, there is alarming increase in dowry-related suicide cases, besides judicial separation and divorce of distressed wife. Now, the three major acts which govern legal trials in India are IPC, CRPC, and Evidence Act, which prescribes the rules of evidence to be formed during a trial. In view of the above, in the year 1986, Section 304B of IPC was added, which provides punishment in the cases of dowry. 498A of IPC further makes cruelty to a married woman by a husband or by her in-laws punishable with 3 years of imprisonment. So in Shobha Rao, in one of the cases, in Shobha Rao versus Madhukar Reddy, the Supreme Court succinctly summed up the scope of cruelty by pointing out that it covers any willful conduct which is of such nature as is likely to drive a woman to commit suicide or to cause grave injury or danger to life, limb, or jeopardize the health of the women, or harassment of the women where such harassment of the women is intended to coerce her or any person related to her to meet any unlawful demand for any property, valuable security, or is on account of failure by her or any person related to her to meet such demand. Now, this was further augmented by Section 198 of CRPC, which envisages that the cognizance of an offense of cruelty must be taken on police report or a complaint made by the aggrieved person, or by her father or mother, or brother or sister, or by her father's brother or mother's brother or sister, with the permission of the court, by the person related to her by blood, marriage, or adoption. Fully cognizant of the fact that young married women are subjected to cruel treatment within 4 walls of matrimonial home. Now, this Section 113B of Evidence Act contains a presumption as to abetment of suicide by husband or abetment of suicide by husband or in-laws of a married woman, where she commits suicide within 7 years from the date of her marriage. Now, concluding with the observation that the Dowry Prohibition Act 1961 was passed with good intention to curb the menace of dowry, but as a matter of fact, the enforcement of the act was a bare minimum. It had neither any deterrent effect nor reformative role. Most of the bride burning incidents was consigned to police record as accidental suicidal. The law needs to be suitably amended to provide capital punishment in cases of proven dowry death. The evil of dowry is basically the problem of society, and it is engulfing the whole society, irrespective of any religious or caste consideration, and no law can cope up with the problem or eradicate the evils of dowry. Now, a change in the outlook is required unless the social conscience is awakened towards the hardship caused by the dowry. The evil cannot be eradicated. There is need to educate the masses regarding the problems connected with the dowry. The incidents of grown-up girls remain unmarried only because their parents could not afford to meet the demands, or would be in-laws is shame or for so-called modern and civilized society. So the blame to be fixed on one who demands or on the one who offers is difficult to answer. But unless the society effectively respond to such evil, we will keep singing "Na saas mare na nanad kate, bahu ka hi kyun stove fate." With this, I would like to end my presentation. Thank you so much for your patience.
Thank you, ma'am, for giving your valuable insights on the subject. Now, I would like to invite Ms. Renuka Sudhir Moore, Dr. Punjab Rao Deshmukh College of Law.
Hello, sir.
Yes.
Hello. Kindly allow me. Yes, sir. Kindly allow me because I have to go to college.
Okay,
Just
sir.
because it's the admission, sir.
Give me 1 minute, sir. So now I would like to invite our next presenter, Dr. Rajesh Patil from Dr. Punjab Rao Deshmukh College of Law, Amravati, Maharashtra. And title of his paper is The Changing Paradigm of Law of Maintenance in India. Dr. Rajesh Patil.
Yes. Is my screen visible, sir?
Yes, sir. Your screen is
It is
visible.
visible, Rajesh ji. इसको F5 press करिए एक बार, so that it can come as a slideshow.
Okay. Okay, sir. Is it visible now?
Yes, sir. It is visible. But yes, sir. It is visible.
Yes. Yes. Shall I start with my presentation?
Yes, sir. Please continue.
Okay. Sir. So the topic of my presentation is the changing paradigm of law of maintenance in India. So basically here I would be focusing on how the law of maintenance, which was once meant for the poor and needy wife, has now got a tremendous change with the contemporary changes in the form of live-in relationships and the educated wives being claiming the maintenance. So basically the right to maintenance of the wife was always considered as an important right. It was always considered that a husband was under the obligation to maintain his wife. The Indian jurisprudence actually provided as a statutory right. In the case of Bhagwan Dutt versus Kamla Devi, the court held that it is necessary as a measure to prevent vagrancy. It has a social purpose behind it. So that was the background, or in fact, the traditional jurisprudence behind granting right of maintenance to the woman. It was recognized by the judiciary, higher judiciary as well. Since your guidelines say that I have to mention the objectives, it was basically to study and analyze the changing dimensions of maintenance in the light of latest judicial decisions. Hypothesis would be there seems a considerable shift in the jurisprudence as regards to granting of maintenance in India. And basically, I would be doing a doctrinal research where I would be studying mainly the provisions, and I have studied mainly the provisions and the case laws. So as we all know about the concept of maintenance, a person is entitled to basic needs like food, clothing and shelter. It is a moral and statutory obligation on the man to provide maintenance to his wife, children. And the amount can be paid by doing one lump sum payment or by way of periodical payment. This is all basic. We all know this. Law relating to maintenance, we have several statutes dealing with the law of maintenance, Hindu Adoption and Maintenance Act. For Muslims, we have Muslim Women Protection of Rights on Divorce. Indian Divorce Act also provides for maintenance. Then we have Section 125, basically, which I would be dealing with. So the first and foremost challenge to the law of maintenance comes in the form of live-in relationships. We are seeing that there are more and more cases coming before the court where the court is dealing with whether to grant a live-in partner maintenance or not. So basically, we have cases coming under two different laws, Section 125 of Criminal Procedure Code and Domestic Violence Act, about 125 of CRPC, the law says it can be granted only to legally wedded wife. Domestic Violence Act, however, says the relationship can be in the nature of the marriage. However, when we look at the decisions which were given in 𝗕𝗵𝗄𝗵𝗂𝗂, where the court held that the Domestic Violence Act, which provides for the relationship in the nature of marriage, cannot be applied, the live-in relationship cannot be applied, cannot be called as the relationship in the nature of the marriage. And therefore, the live-in partners were devoid of the were not given the maintenance. However, in Chanmunia versus 𝗕𝗓𝗄𝗂𝗃 the court held that the Domestic Violence Act covers under its ambit the live-in relationship, and therefore the maintenance can be given to the live-in partner. Indra Sharma versus Union of India, the court held that the maintenance can be given to the live-in partner only if she was not aware that the person had another wife. So what here I want to classify is that live-in relationship can be of two types. Modern live-in relationships, where the couples are living together just to test the compatibility of each other, and the extramarital mostly relationships of the husband, which can be called as traditional live-in relationships. So basically what we are doing is even in when we look at these cases, we can easily see that all these cases were relating to the traditional live-in relationship, where the husband had another woman in relationship, and there the court were deciding the scope of the 125 of CRPC and the Domestic Violence Act. So this is the foremost challenge to the law of maintenance, where the court is under dilemma whether to grant maintenance to the live-in partner or not. Because in Radhika versus State of UP, the Supreme Court was very clear that maintenance under 125 can be given only to legally wedded wife and not to any person. The same way the views held in Velusamy versus D. Pachaimal, where the court refused to grant maintenance to live-in partner, even under the Domestic Violence Act. And even if we look at the 𝗙𝗵𝗄𝗃𝗓, here 𝗙𝗵𝗄𝗃𝗓, who is the author of Domestic Violence Act, she says that the purpose of the Domestic Violence Act was not to grant maintenance to the live-in partners, but to the other woman who is in relationship with a wedded husband. So that is the foremost challenge where the court is dealing with, and the court there is a lot of confusion regarding this, whether it can be granted to a live-in partner or not. The another dilemma, or in fact another challenge that is posed before the court, is the claim of maintenance by an educated wife. And we can easily say that in Rupali Gupta versus Rajat Gupta and others, the court held that educated wife cannot claim maintenance. Similar views have been held in other cases. However, in Arun versus Pallavi Sharma, the court were of the view that being educated and being earning are two different concepts. So even if she is educated but she is not earning, the maintenance cannot be denied to her. So this is another challenge to the law of maintenance, where we are seeing more and more cases coming before the court, in which the educated wife is claiming the maintenance. And the court is of the opinion, in fact, there are several conflicting decisions, where in some cases the court have held that even an educated wife can claim maintenance, whereas in other cases, the court has held that the educated wife cannot claim maintenance. So the law of maintenance, which was basically to protect the poor and needy wife, legally wedded wife, now is facing two foremost challenges, one from the living partners and another from the educated wife. And there is a lot of dilemma even when we go through the decisions of high courts and Supreme Courts. Even the Supreme Judiciary seems to be in dilemma. In some cases, they are granting maintenance, whereas in other cases, they are refusing the maintenance. So in the conclusion, I would say the maintenance provisions under Indian jurisprudence were essentially meant to protect the poor and deserted wife. However, dealing with the claims of live-in partners and deserted educated wife for maintenance, there seemed to be a judicial dilemma whether to apply the provision to such cases or not. The judiciary has rightly stated the claims of female in live-in partner and educated wife, which is being through coping with the philosophy behind the provisions as to the maintenance. In future, we will be seeing lot and more cases coming before the court, and the court would be really tested whether this philosophy which was behind the law of maintenance should be changed or not. Thank you.
Thank you so much, sir, for giving your valuable insights on the subject. Now, I would like to invite Ms. Renuka Sudhir Bor from Dr. 𝗕𝗫𝗄𝗏 𝗦𝗂𝗃 College of Law, Amravati, Maharashtra, to present her paper titled The Legal Intricacies of Surrogacy in India.
Hello, everyone. May I start, sir?
Yes, just a second, ma'am. Dr. Patil, can you close your PPT? Yes, ma'am, you can start.
Hello, everyone. I am Renuka Sudhir More from Dr. 𝗕𝗫𝗄𝗏 𝗦𝗂𝗃 College of Law, and my topic for presentation is the legal intricacies of surrogacy in India. Am I audible, sir?
Yes, ma'am, you are audible, but there is some weird noise from your background.
Sorry for that, sir.
Please turn on your video also.
Yes, please turn on your video as well.
It's on, actually. Let me check.
And we are unable to see you.
Okay. Okay, let's first move to the introduction part. The children are the brightest treasure we bring forth in this world, and the birth of a child in the family is seen as the completion of the family, wherein couple are entrusted with the new role of parents. But in some cases, where it is not possible to beget child by natural means, traditionally where various rituals and practices were seen followed to overcome childlessness, and some of these practices are fasting, visiting temples, etc., which are being followed even today. For such infertile couple, there are other options such as adoption. But as we know, this mechanism could not fulfill the innate desire of an individual to have genetically related child of their own. This led to this desire to have genetically related child led to emergence of newer methods and experiment in the field of human reproduction, which resulted in the development of assisted reproductive technologies to overcome childlessness and to help individual to beget a child. The most commonly used ARTs are artificial insemination, in vitro fertilization, and surrogacy. The right of surrogacy can be claimed as a fundamental right under Article 14 and 21 of the Constitution, but at present there is no legislation to deal with this subject in India. Even though it involves right of multiple individuals such as surrogate mother, natural parents, and the surrogate child, most of these rights are conflicting with each other. The present study seeks to study this and propose possible solutions to it. For the proper understanding of the issues involved therein, we need to understand what surrogacy actually means. The word surrogate has been originated from the Latin word which means to act in place of or substitute. Surrogacy is the practice wherein woman carries a child of another with intention that the child should be handed over after the birth. Surrogacy is a process by which the intended parent take help of surrogate woman who agrees to carry the child for full term and also to relinquish her parental right over the child after the birth and hand it over to the intended parent. The surrogacy acts are generally carried out in the form of contract. A surrogacy contract involving payment of a monetary compensation to the surrogate is considered as a commercial surrogacy contract, while a surrogacy contract in which no monetary compensation is given to the surrogate for her service is considered as an altruistic surrogacy contract. Since 2000, India has become one of the top international destinations for surrogacy. Anand in Gujarat is considered as a surrogacy capital in India. In 2012, it was estimated that more than 25,000 children had been born through surrogacy in India, half of them for international parents. In this country, risk of exploitation is a key concern, as poverty is a major national challenge. Let us further move towards the human rights and constitutional aspects of the surrogacy. Various human rights documents such as the Universal Declaration of Human Rights 1948, the International Covenant on Civil and Political Rights 1966, the International Covenant on Economic, Social and Cultural Rights 1966, and the Convention on the Elimination of All Forms of Discrimination Against Women 1979, as well as regional human rights documents like the European Convention on Human Rights 1950 and the American Convention on Human Rights 1969, has recognized the innate desire of an individual to beget a child as a basic human right. The right to procreation is expressly mentioned under the Convention on the Rights of Persons with Disability 2006 and the Protocol to African Charter on Human and People's Rights 1998. The court in India has also recognized right to procreation as an integral part of right to life and personal liberty. In the case of 𝗟.𝗫𝗄𝗃 versus State of Tamil Nadu, wherein the court held that the citizen has right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. The matters relating to procreation and pregnancy have included under the right to privacy. Also, in the case of 𝗏𝗃 𝗏𝗏𝗃 versus State of Andhra Pradesh, the court held that the right to make decision about reproduction is essentially a personal matter. Let's further check the validity of surrogacy agreement under the Indian Contract Act 1872. According to Indian Contract Act, an agreement enforceable by law is a contract. Section 10 of the Act provides the essential of valid contract, and the surrogacy agreement satisfied all those essentials. One of the essential of the contract is the lawful object and consideration. The object of the agreement would be unlawful if it is forbidden by law, or if permitted it would defeat the provisions of any law, or is fraudulent or causes injury to the person or property of any other, or where it is immoral or opposed to public policy. The object of surrogacy agreement is to beget a child is in consonance with the national and international human rights provision, cannot be said to be unlawful. It does not defeat the provision of any law, or nor it is fraudulent in nature. Also, in India, there is no legal provision that prohibits the getting of a child through surrogacy. Hence, a surrogacy contract can be considered lawful in India. Am I audible?
Yes, ma'am, you are audible.
Okay. Sorry.
Ma'am, have you concluded your presentation?
No. I'm just. Then let's further move to the ICMR guidelines on surrogacy. ICMR guidelines 2005 have been drafted by the Indian Council of Medical Research for regulating the conduct of ART clinic offering surrogacy in India. This guideline prescribe conduct and use of assisted reproductive technology, procedure and treatment by fertility clinics. The ICMR prescribes informed consent, which after duly counseling couple or oocyte or semen donor. It also prescribes informed and written consent should be taken from both spouses as well as donor. They should be explained various risk factors associated with procedure in simple language. This include the risk associated with ovarian hyperstimulation and aesthetic procedure and invasive procedure like laparoscopy, aspiration of ovum, etc. They should be also explained possibility of multiple pregnancies, ectopic gestation, increased rate of spontaneous abortion, premature birth, higher prenatal and infant mortality, risk of treatment to women, and risk associated with multiple pregnancies. but these guidelines are only recommendatory in nature. Next is 228th Law Commission report on surrogacy. The Law Commission of India report on surrogacy has taken into consideration several areas of surrogacy in India, the prevailing scenario of surrogacy, and also recommended standard for the same. The report has regarded that the law related to the surrogacy are highly complex and advised a pragmatic approach while legislating on this issue. The report states that as far as legality of the concept of surrogacy is concerned, it would be worthwhile to mention that Article 16 of the Universal Declaration of Human Rights 1948 says that the men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and found a family.
I'm sorry to interrupt, but your time is over. Kindly conclude your presentation.
Okay, can I take 5 minutes more?
Okay.
Okay. Let's further move to the main features of the surrogacy regulation bill. The main features of the surrogacy regulation bills that first one is the bill effectively bans foreigners to seek an Indian surrogate mother. The intended couple shall not have any either issue of their own or adopted or surrogated. The intended couple must be between the age of 23 to 50 for female and 26 to 55 for male. They must be legally married for at least 5 years. The surrogate mother must be willing to deliver the child, and there must be the written informed consent by her. The surrogate mother must be from close relative of the intended couple, and she must be between the age of 25 to 35. The surrogacy clinics must be registered. The surrogacy regulation bill bans the surrogacy for commercial purpose. And it also prescribes imprisonment, which may extend to 5 years and fine up to 5 lakhs. The regulation and implementation of surrogacy shall be done through the National and State Surrogacy Board. The bill proposes for establishment of national and state surrogacy boards. Also, the surrogacy bill was reintroduced in the Parliament in 2019. Let's further move to the judicial decisions. First one is the 𝗬𝗵𝗵𝗵𝗃 versus 𝗬𝗵𝗵𝗃, where it was held that I will jump up to the 𝗓𝗏𝗏𝗃 versus Union of India, where 2 twin babies were born to the Indian surrogate mother in 2008. Their biological father and mother were German national, and they were denied the Indian passport under Indian Passport Act, for not being an Indian citizen. However, court held that the babies born in India to gestational surrogate are Indian citizens are entitled to the Indian passport. Then there is certain conflicts between the rights of the intended parent, surrogate mother, and child face different issues. Means, what if there is a risk of both surrogate mother and child, and who will be responsible for the loss and such issues? Then I will conclude my presentation. The rights of surrogate parents and natural parents and the child are of key importance. The right to motherhood is a human and fundamental right for natural mother, but it also affects the right of procreation of surrogate mother. Allowing surrogacy agreement in the poor countries like India would mean exploiting women for surrogacy. The ART bill introduced by the government in 2008 as well as in 2010, and the subsequently surrogacy bill in 2016 for regulating the practices related to surrogacy in India have not yet been enacted as a law. In absence of such specific legislation, the ICMR, a national guidelines for accreditation, supervision, and regulation of ART clinics in India, are only available regulatory framework. These guidelines are not binding. The Law Commission of India has also recommended the need for adopting a pragmatic approach to regulate surrogacy in India. And in the case of the judiciary has also emphasized the urgent need of legislation to deal with the various issues raised by the surrogacy. In the absence of any specific legislation on the subject of surrogacy, it is really hard to regulate this practice, which has been boon to millions of childless couples. No law in India prohibits surrogacy. The Law Commission in India, in its 220th report, has categorically stated that surrogacy agreement will continue to be governed by the contract amongst the parties, that the ICMR guidelines also provides for such agreement. The Surrogacy Regulation Bill 2016 aims at banning commercial surrogacy so that the establishment of national and state surrogacy board and registered surrogacy clinic will regulate the surrogacy in India. The enactment of the Surrogacy Regulation Bill will govern the surrogacy issues. Thank you.
Thank you, ma'am, for sharing your valuable insights on the subject. Our last presenter of the session is Mr. Krishnendu Ghosh, student of BLLB School of Law, UPES Uttarakhand, and the title of his paper is Live-in Relationships. Is it time to have a statute? Mr. Krishnendu Ghosh.
Hello. Good afternoon, everyone. Am I audible?
Yes, sir, you are audible.
So, good afternoon to all the delegates and all the keynote speakers present here. I am myself Krishnendu Ghosh, and I am a fourth-year student pursuing BLLB Energy Laws from School of Law, UPES, Dehradun. My topic is live-in relationship. Is it time to have a statute? So, one of the hypothesis for for this paper is that we need a uniform legislation regulating live-in relationships in India, and the methodology which I have adopted is doctrinal research. Now, moving towards the evolution of a live-in relationship, we know that in the ancient times, Maharajas used to be in live-in relationships with many women, and they used to keep it confidential from the mainstream society as well as their lawfully legal as well as their wives. Now, moving to looking at the contemporary times, this kind of relationship has a great number of followers, or a lot number of people are following this. Whether first it had started, let's say, it is very much prevalent in the Western countries, and right now the wind is also blowing towards India as well. Now, I would like to cite two cases which will mark the transition to the contemporary times by the judiciary. Now, one is the 𝗖𝗄𝗃 Kumar versus State. In this case, live-in relationship is a kind of relationship which is of convenience, as this was stated by the honorable benches, and where parties decide to stay together and leave each other at their own will. But this relationship is not a marriage. Now, another case is 𝗏𝗏 versus DY, Director of Consolidation and others. In this case, the court recognized live-in relationship as a legal marriage. Now, the fact is that the couples in this case lived for almost 50 years together, and so when the case actually ended up in the court said that presumption lies towards wedlock, where couples have lived as husband and wife, where they have projected themselves as husband and wife to the whole society. So this is one of the landmark case which said that, or which held that live-in relationship is a legal marriage. Now, there are some aspects which we need to look upon while looking into this live-in relationship. Now, one is what is the meaning of the term marriage? As the keynote speakers had in the beginning of the session had said that what exactly does marriage mean, especially to the Indians? But I would like to say that it's not the end point of a relationship. A live-in relationship is not the end point of a relationship, but live-in relationship may mark the beginning of a long-term commitment, and marriage is the initiation of such long-term commitment. Section 7 and Section 5 of Hindu Marriage Act says that what are the ceremonies for Hindu marriage, and Section 5 says that conditions for Hindu marriage. Now, if we look at these terms, marriage and live-in relationship, marriage is a well-established social institution, but there is no such status to live-in relationship. Live-in relationship can lead to marriage, but it itself may not be marriage as of the general understanding prevalent. Now, the other term which we need to understand is what is the meaning or what is the legal position of the term wife. Now, everyone knows that wife has been defined in Section 125, Clause 1, Explanation B of CRPC, which says that wife is one who is divorced or obtained divorce from husband and did not remarry. Now, 𝗖𝗄𝗃 versus State of Gujarat is one of such cases where the court held that wife can only be a legally wedded wife and no one else. But there is a landmark 𝗦𝗵𝗵𝗃𝗃 committee report with respect to the criminal amendments, wherein it was stated that the meaning of the term wife has to be extended, which is given in section 125 of CRPC. Now, wife should also include those who are living in for a considerable period of time with each other. So this was one of the suggestions given by the 𝗦𝗵𝗃 committee report. And the state of Maharashtra was one of the states just after this 𝗦𝗵𝗃 committee report, which sought the extension of the term wife given in section 125 of CRPC. Now, let me tell you one of the very landmark cases when one is discussing this specific topic, that is Chermulia versus 𝗂𝗏𝗃𝗃 𝗏𝗃. Now, this case also cited the findings of 𝗦𝗵𝗃 committee report, and they also said that those couples who are living for a considerable period of time, then that person should also be included within the definition of the term wife. But this Chermulia case was contrasted by another landmark case, which needs to be mentioned, because it's not that the pro things should also be mentioned, but the against things should also be mentioned when one is looking or trying to dig deeper into any of such topics. Now, that is Savitaben Somabhai versus state of Gujarat. It said, now it is very important what the court has cited here. Court said that how woman is treated is immaterial, but what matters is the intention of legislation. So the court has given first priority to the intention of the legislation and not to the dignity and the status of women in our society. So another thing is relationship in the nature of marriage. We all know that Domestic Violence Act is a very landmark and progressive act which has been legislated by our parliament. Now, Domestic Violence Act also defines the term shared household, aggrieved person, and domestic relationship. But what they do not mention is what they do not give a broad understanding is about the term the relationship in the nature of marriage. Now, what is this relationship in the nature of marriage? Now, for this, we need to look into the 𝗔𝗵𝗃𝗃 versus 𝗔𝗶𝗃𝗃 case, which is also one of the landmark cases given by the Supreme Court in the year 2010. Now, there are certain guidelines which will help us to determine what will come under the term live-in relationship or relationship in the nature of marriage. They said that the couples should project themselves to the society as akin to spouses. Now, they should be of legal age to marry. They should be qualified to enter into marriage, but they should be unmarried and not married. Now, this entering into this live-in relationship should be a voluntary act by the couples and project as spouses to world for a considerable period of time. Now, one of the gray areas also here is what is this considerable period of time? The court has also said that considerable period of time doesn't mean that it will be just for 1 week or 2 weeks or 1 month or 2 months. No, considerable period of time will depend upon the case, is a subjective term and will vary case to case. Now, another case which has supported the 𝗔𝗵𝗃𝗃𝗃 case as well, but has also given some broad guidelines, but these are not exhaustive guidelines. Now, that is Indira Sharma versus V.K.V. Sharma as to what will constitute a relationship in the nature of marriage. So they have given certain guidelines. Now, let us look at these guidelines. That is, the duration of relationship should be of considerable period of time. Most of these guidelines have already been cited in 𝗔𝗵𝗃𝗃𝗃 case. Now, the parties should be in shared household. They should financially support each other. They should buy property with each other's name and buy property in concern. They should buy property with the help of each other. Now, the domestic arrangement should be such as if they are in the nature of marriage. If someone goes to their house and look into the couples, they should believe from the very first instance that these people are husband and wife. Now, the couple should exercise sexual relationship not for pleasure but for emotional gain and procreate children. Now, procreation of children has been cited one of the important indicators in this case by the Supreme Court. Now, that is why procreation of children has been cited as an important indicator, because it will denote that the people are very serious about this relationship and not in the relationship just. They should also project that they are husband and wife, and their conduct and intention of the parties should reflect that they want to be into a very serious relationship. Now, is that there should be uniform legislation pertaining to live-in relationship in India. I know there are some people or some of the people in our society still consider live-in as a taboo. But a time has come where we need to be progressive and give a legal stance, legal support to this live-in relationship. The law should specifically determine the rights and liabilities of each of the partner who are in this relationship. The law should not be biased and only deal with women as aggrieved party, because aggrieved party in section 125 in CRPC has in Domestic Violence Act has been termed as aggrieved party is a woman, but it should be gender neutral, and aggrieved party should also be it should be gender neutral, and both the parties can be aggrieved party. The status of children born out of this engagement, although has been dealt by the code, but their rights, liabilities, and inheritance should be clearly mentioned to rule out any type of confusion. The status of children has already what will be the status of children has been given in the 𝗏𝗏 case, but it has been not very exhaustively defined that what will be the exact status. So that should also be elaborated by the parliament, that what will be the status of children who are born out of this relationship. I would like to move towards the conclusion of my paper. Now, we know that change is inevitable and something which is sure to happen, because it is a transition. And if we look at the ancient times, we have seen that Sati Pratha was the abolition of Sati Pratha was not welcomed by the society at that time, but gradually people have welcomed that. So I also believe that live-in relationship may not be, many people might not favor live-in relationship, but now time has come that we should also give some thought that what is this? In the contemporary times, if we look on, is a global village where everyone is easily connected to each other, and especially due to this COVID, all are virtually linked to each other. So I believe that what has come into the Western countries or many other countries of the world should also be looked upon, that what is this, and whether we can inculcate this in our society or not. If we can inculcate in this in our society, then whether legal standing can be given to this or not. So this is what I believe. Thank you very much for giving me the opportunity to present my paper. Thank you to everyone.
Thank you, sir, for sharing your deep knowledge with us. Thank you so much to all the presenters for sharing their valuable insights and knowledge. Now it is my honor to invite Dr. 𝗏𝗏 Assistant Professor, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. Ma'am has done her PhD from University of Delhi on the topic Corruption and Anti-Corruption Laws, Constraints in Investigation and Trials of Corruption Cases. Ma'am has 15 years of teaching experience with Guru Gobind Singh Indraprastha University and other prominent institutions. Her area of interest includes criminal law, criminal procedural laws, criminology, victimology, and penology. She has published 14 plus papers with various publications. Now may I request Dr. 𝗏𝗏 to kindly throw some light on this technical session and conclude it with her valuable thoughts. Dr. 𝗏𝗏.
Good afternoon, everyone. It was nice listening to all the participants' views and their ideas about the very, very important area of law, as being said by the keynote speaker in the morning also, Professor Mehra. Yes, I went through all the papers for the obvious purpose, as in for adjudicating that which one would be the best paper. But yes, what I would like to say in the very beginning is that when I received this compendium, I was looking, as in, this is my opinion, that I was looking for a paper which might be in the another technical session I'm not aware about. But I was looking for a paper which actually talks about, that is my, this thing, what I was searching for. Maybe for my own interest, I was, it was serving my own interest, that I wanted to know that what any of the researcher would say about that, what impact does right to privacy judgment, as in Puttaswamy, would be having on the family laws, as in the various areas in family laws, may it be regarding inheritance or marriage or anything like that of, because we will all agree that yes, it would touch every aspect of family, which is the first basic unit of a society in itself. So yes, I was trying, but I was it's my bad luck that I didn't receive any of the papers on that. But maybe in the next technical sessions we would be having any of the paper, or maybe we'll wait for another conference to be organized by CPJ on the where the researchers will touch this, which anyways, but yes, I had I patiently listened every speaker's point of view, and they actually elaborated in a very nice manner whatever they were made be like live-in relationship or dowry or surrogacy, and maybe uniform civil code, which is quite an overdue kind of this thing that yes, we all been talking about right from that, because being a criminal procedure student, as in criminal law student, I generally, when I take the topic of maintenance, and especially maintenance when I take the topic of section 125, I generally highlight and try to highlight that what are the pros and cons of not having a uniform civil code in this very area, though it is having pros and cons in every this thing in every area, as in as in pros and cons. I'm not saying particularly saying that there are certain pros, but yes, just using the term in the very combined manner. So yes, we all know, yes, the students, they actually touched every aspect in my technical session. They touched every this thing, and I was very excited listening to the tax thing, as in this was something, because as a law student, this is may it be surrogacy, may it be this thing, may it be maintenance or uniform civil code, we have been talking about in classes and various conferences. But for the very first time, I actually heard this very idea of Hindu undivided family as a taxable entity. So my Ghazala, are you there?
Yes, ma'am. Yes, ma'am.
Okay, so I would just like to ask you in a very very few this thing very precisely, that what are your you have completed this study? You have completed this?
Yes, ma'am.
Okay, so what are your findings, as in, because maybe I didn't comprehended that very this thing, that what are your ideas, what are the changes that you are suggesting as far as to tackle this very concern in the area of law, as in what are your suggestions per se?
Ma'am, actually, what I try to focus in my research paper is that how Hindu undivided family is used as a colorable mechanism for tax avoidance. So during my research, I found that this HUF has been used as a colorable mechanism for tax avoidance purposes. And I have also discussed about I have elaborated the three aspects wherein it has been misused. Like I talked about in the very first instance regarding the intersection between succession and inheritance laws. Then I have discussed about the preferential treatment also. Now, when I talk about the preferential treatment, I said that the special recognition which is given to the HUF, it is against the spirit of the Indian Constitution. And when I say that it's against the Indian Constitution, I mean to say that specifically recognizing and treating HUF as a separate taxable entity hampers the fundamental object of secularism. See, it cannot be considered that only Hindus have large families. Primarily, British pampered the Hindu feudal families with a view to earn their loyalty. Now, the British did this by ameliorating the position of Hindus over other Indians. So British wanted to seek support.
To interrupt you, but is there any data which shows that the tax evasion is being done by Hindu undivided family? Is there any data? Is there any study that is being previously conducted? Because I guess your paper is of doctrinal nature. So you might have relied on in your literature review, was it anywhere that you could actually trace out that yes, the data is there on which you actually formulated this hypothesis?
Yes, ma'am. I have conducted a doctoral research and I have referred to various reports and recommendations of various committees. Particularly the Law Commission specifically emphasized on this aspect in the year 2018. And the Law Commission was of the view that the institution of HUF is neither conducive for tax regime nor congruent with corporate governance. It was only for the purpose of taxation that the HUF was accorded a special status. Now, this Law Commission in 2018 specifically mentioned that this special status is now being misused for tax evasion. So it further said that the British were unable to handle the socioeconomic structure of the Indian families, hence gifted the institution of HUF to these families. So justifying the existence of HUF on the ground of inherent feelings at the cost of nation's revenue may not be justifiable. This is what the Law Commission's opinion was. and it was in the year 2018. And in this area, the various committees were also constituted since 1936. And since then till now, till date, there have been various recommendations that I have already talked about in my research paper.
Okay. So what are the changes that you are suggesting that it should be? What laws
Yes,
you are suggesting to be amended?
I want to suggest that some immediate action against the problem of tax avoidance by HUF is the need of the hour, and some more strong system, the strong taxation system or more resilient taxation system should be should be adopted to curb the tax avoidance by HUF. And reformation in the personal taxation law is also pending since very long. So this is the need of the hour. And the acceptance and recognition of HUF as independent taxable entity provides several advantages, as I have already discussed. But it must not be forgotten that these advantages at the same time, threatens the overall object of equity and stability. So what I feel is that the distinct treatment should not be accorded to HUF. There must be some aspects should be overlooked for the purpose of tax assessment. And there is also one more aspect that I did not touch upon, but I have written in my research paper, that there is a practice of gift which is very much prevalent. So the practice of gifts pertaining to HUF within the family should be avoided. Also, the gifts that are made to people other than the family members must be considered as the income of the recipient. So some immediate action needs to be taken. And what I mean to say is that opening the economy with more liberal tax assessment policies will lead to decline in the need to avoid tax. That is what so basically reformation is the need of the hour. Reformation in the taxation system, more taxation, more resilient taxation system should be adopted. And that is how we can, curb the practice of tax avoidance by Hindu undivided family.
Thank you. So,
thank you.
Any other participant who would like to ask any question regarding any paper? I would, because there was a question answer session as well. Though one thing that I would like to say is, I think I don't remember the last paper which was dealing with live-in relationship, as in, is it time to have a statute? May I have the author, please? Krish Ghosh.
Mr. Krishnendu Ghosh.
Krishnendu, yes. Your paper, it was written Krish Ghosh, yes. So can I just ask that what made you to come to the conclusion or suggest this topic, as in that there is a live-in relationship needs to be legislated? So what are the key points that you actually came to this, that yes, live-in, there is a time? Because law, I don't think so is an answer. As far as this is my opinion, you might differ with me. That is law an answer for every problem? And what is your view about that? You came to this conclusion that yes, live-in relationship, is it a time to? What made you think that? Is live-in relationship not is covered sufficiently enough?
I personally believe that you rightly said that law is not the solution to all the problems, but at least being a legal student,
First of all, let us agree that it is a problem. First of all, let us agree to this, that is it a problem?
Yes, ma'am. It is a problem.
Okay. In what aspects, in what areas it is a problem? As in, what is problematic in live-in relationship?
Ma'am, the problem lies with the fact that there are people, there are couples right now who enter into this live-in relationship, but they are not very much serious about it. So as a result, they just enter into this relationship for 2 months, 3 months, 4 months, 5 months, and just separate with each other, just for say a few, let me be very frank, for sexual gains or for some other purposes. Because right, sorry.
Yeah, you please continue. I'm not asking.
Yes, ma'am. So I, as a law student, I personally believe that law is not the solution to all the problems, but at least we should endeavor, because we should endeavor to give solutions to all the existing problems in our society through some legal background, legal standing. So that is the important. That is the primary instance which compelled me to work on this project.
What are your views about raising the legal age of sexual relationships? As in, till now it is 18. Before that, it is statutory rape. Consent doesn't matter. But suppose if today we are having a debate on increasing this age. So what are your views about that?
Ma'am, I believe that it should be, although there are points that, although there are voices that the legal age should be increased, but I believe that 18 is fine. because people in our society are matured enough to understand what exactly does this mean. So I
Okay, so
am in
how
the field.
law will bring the seriousness in amongst the people who are living together, who decide to live together?
Ma'am, for example, with the
What are your suggestions? Because I could, when I was reading your paper, as in you actually in the end of it, you summarily concluded it by just writing an epilogue. So suggestions you give. Can you just reiterate your this thing, as in what are your suggestions as far as this particular concern of yours is concerned?
Ma'am, I would say, ma'am, can you please elaborate? I mean, do you want
What
me
are
to
your
elaborate?
suggestions? You want a separate law? You want certain laws to be changed? What are your suggestions as far as, first of all, I was just trying to find out that what are your, because I could not trace any kind of concerns in your paper, as in what is problematic in this thing. You discussed that whether it is in nature of relationship or not. So what are the areas that you find that live-in relationship statute or the law, or suppose if we make changes, should incorporate within it? As in, what are those areas? For example, one is maintenance. Let us agree to that. One is maintenance. Second?
Second thing, which I would like to, is the broad extension of the meaning of the term wife given in section 125 of CRPC.
Okay, that will automatically be done if we cover. Then anything else you want to suggest?
Ma'am, the considerable period of time, which has not been elaborated by the court as of now, because it is a very
penalty for it. If the person suppose decides to move out of a live-in relationship, you want penalty. What kind of legal redressal you wish to?
If not penalty, that at least there should be some check boxes which will determine that what will be the considerable period of time and whether their intention was there to enter into that kind of relationship.
Okay. The floor is open. If anybody wishes to ask any question, can do. Thank you.
What would be the significance of your study, Mr. Ghosh? One question from my side only.
Yes, sir.
One question, that is, what would be the significance of your study?
So the significance would be that because if you look that there are lot number of people in this, people will become aware. The first important thing is that awareness, because they do not understand the exact meaning of the term live-in relationship, and they just involve into this for fun and excitement. But people are not serious about it. So maybe we can give some kind of awareness can be brought into the society through this study. This is what I believe.
Okay. Okay, Vivek, you please.
Sure, sir. Thank you so much, ma'am, for your words of wisdom and for taking out your valuable time for today's conference.
Learning is mutual. I also learned reading these papers. That is why I said that I was looking for a paper which was dealing with that, so that I could cover, I could have a reading material to maybe teach in this thing. So maybe I would be attending the next session to listen the papers. Thank you.
We would love to hear on the topic, Justice Putta Swami case on some other day. Thank you, ma'am. I again, on behalf of CPJ College of Higher Studies and School of Law, would like to express my deepest gratitude to Dr. Anuj K. Vaksha and Dr. 𝗤𝗏 Gautam for giving us their valuable time. I would also like to thank all the presenters for presenting their studies on this forum. Thank you everyone for your valuable time and efforts. Now we will take 30 minutes lunch break and get back at 1:30 p.m. for second session. I would also like to inform that announcement of Best Paper Award will take place at valedictory session. I also like to request delegates and guests of technical session 1 kindly give your interview bite after this technical session. The delegates will receive the link in their official WhatsApp group of National Conference, and the guests will receive their link on their personal WhatsApp. Thank you so much, everyone. Hope to see you all in the valedictory session.
Thank you, Yugam sir. Thank you, Amit sir. Thank you, Vivek ji.
Thank you so much.
Thanks, Dr. 𝗤𝗏. And would be kindly be there in the valedictory session too,
Yeah,
Dr.
I will be. I will.
And Dr. Anuj too. Yeah.
Thank you so much, ma'am. Thank you so much.
Perfect.
Thank you, everyone. Thank you, ma'am.
Thanks.
वक्रतुण्डाय गौरीतनयाय धीमहि कंगड़े दे विच लगे नग सतरंगे नी गल्ले गल्ले आशिकां तो दिल यही मंगे नी तेरा हो सकता है मुझे भी देखो मेरा बनने लगा देखो तो हसीना तो वाना भी करीना तो दिल तोड़ने वाली है तेनू जेल हो जवे नी तू आउण वाले पे
A very good afternoon to everyone. I, 𝗕𝗎𝗄𝗏 𝗦𝗐𝗍, Assistant Professor, School of Law, welcomes you all for the technical session 2 of the National Conference on the theme Family Law, Contemporary Challenges and Solutions. Today I am honored to welcome Dr. 𝗏𝗏 Singh, Professor, University of School, Law and Legal Studies, Guru Gobind Singh Indraprasth University as keynote speaker. Dr. Rakesh, Associate Professor, University of Law and Legal Studies, Guru Gobind Singh Indraprasth University as chairperson. I am also privileged to welcome Mr. 𝗖𝗵𝗃𝗄𝗁 𝗏𝗏, Director General, Dr. Amit Jain, Deputy Director, School of Law. We are privileged to have you all with us on our part of our second technical session on family law, contemporary challenges and solutions. To begin with the technical session second, would like to invite the epitome of the CPJ College of Higher Studies and School of Law, Mr. 𝗖𝗵𝗃𝗄𝗁 𝗏𝗏. Director General, sir is a person with the multiple dimensional skills, a product of Delhi University as he has done his graduation in economics from Hindu College and a postgraduate in economics from prestigious School of Economics. Sir is associated with CPJ College from last 8 years. Now he is bringing a rich knowledge to the college with diverse areas. With his sport and hard work, motivation and passion, the college has become one of the leading institutions in India. With the brief, I would love to invite Mr. 𝗖𝗵𝗃𝗄𝗁, Director General, to give a welcome address and to our keynote speaker and chair session on behalf of CPJ College of Higher Studies and School of Law. 𝗖𝗵𝗃𝗄𝗁 sir?
Yeah, good noon.
Yes, sir. Good afternoon.
Yeah, good afternoon.
Yes, sir.
Sorry.
It's okay.
Yeah, please, sorry for a slight delay.
Yes, sir. So shall we start again?
Please.
Okay, sir. A very good afternoon, everyone. I, 𝗕𝗏𝗄𝗃, Assistant Professor, School of Law, welcomes you all for the technical session 2 of National Conference on the theme Family Law and Contemporary Challenges and Solutions. Today, I'm honored to welcome Dr. 𝗏𝗏𝗄𝗃, Professor, University School of Law and Legal Studies, 𝗚 𝗏𝗂𝘂𝗃 University, as keynote speaker, Dr. Rakesh, Associate Professor, University of School and Legal Studies, 𝗚 𝗏𝗂𝘂𝗃 University, as chairperson. I am also privileged to welcome Mr. 𝗏𝗂𝗀𝗡𝗃 𝗏𝗏𝗄𝗃, Director General, and Dr. Amit Jain, Deputy Director, School of Law. We are privileged to have all with us as a part of second technical session on family laws, contemporary challenges and solutions. To begin with the technical session second, I would like to invite the epitome of CPJ College of Higher Studies and School of Law, Mr. 𝗏𝗂𝗀𝗡𝗃 𝗏𝗏𝗄𝗃, Director General. Sir is a person with multi-dimensional skills, a product of Delhi University. He has done his graduation in economics from Hindu College and post-graduation in economics from prestigious Delhi School of Economics. Sir is associated with CPJ College about 8 years now, and he is bringing a rich learning and college in a diverse areas. With his sport and hard work, motivation and passion, the college has become one of the leading institutes in Delhi. Sir, I'd like to welcome you. It's an honor to invite the embodied college of the college, Mr. 𝗏𝗂𝗃 𝗏𝗏𝗄𝗃, Director General, to give an inaugural address, and welcome our keynote speaker and session chair on the behalf of CPJ College, Higher Studies and School of Law. Over to you, sir.
Yeah, thank you very much, Ms. Ishmeet. I hope I'm absolutely audible.
Yes, you are audible.
Yeah. Namaskar, Professor Dr. Kanwal Singh. Very, very warm welcome to you. It's always a great pleasure to have your association with CPJ School of Law. And we look forward for such association in the coming times also. Thank you so much for making it and being a part of this conference and being the keynote speaker. And of course, we will be privileged to have you for the valedictory session also, wherein you'll be addressing in the valedictory too. Thank you so much, ma'am. At the same time, I also give my hearty welcome to Dr. Rakesh Kumar, Dr. Rakesh Singh, sorry, and no two doubts about it. The association with Dr. Rakesh also goes a long way, and we have had a very close association with him in lots of conferences, our seminars, and even otherwise. His advice has always been floating into the CPJ College, where it has really helped the faculty as well as the student fraternity. Today's national conference, we are already through with the technical session 1, wherein we had a presentation from 6 presenters, 6 delegates from across India. And it was very nice to go through their views on different sub-themes of family law. And we have the next session commencing in. I had already said in my welcome address in the morning to Professor Dr. Vinay Kapoor that this conference, which we are holding as of now online, it was supposed and it was scheduled to happen on the 20th and 21st of March 2020. But somehow, because of the COVID and the colleges getting closed just a week prior to that, despite our all things remaining in place, absolutely was finalized and everything, all arrangements being done of all delegates coming from outside Delhi, their stay, etc., etc. But we had to defer it. And then we were thinking of, holding it at once the classes and the colleges, they resume. But somehow it's going a long way and there's not looking any end to it. So looking at that perspective, we thought the 5 events that we had in the national conference 2020, the very first event of that, which was the national conference. So we have picked that, and we already had the first technical session of it. Family law is a very, very contemporary theme. It has always been, I think so, that the first constituent in this whole system of our human mankind has been the family, from where the progeny started and from where we stand today, the world today. I have Dr. Rakesh Kumar and Dr. 𝗏𝗏𝗄𝗃 Singh as the keynote speaker and the session chair for today's technical session 2. I once again say my lot of thanks to them for having made it, and I'm sure that the delegates who are here, who will be presenting their forthcoming papers in this technical session 2 starting now, would definitely be enlightening a lot on the sub-themes of the family law. Thank you so much, and over to Ms. Ishmeet Kaur. Thank you.
Thank you so much, sir, for sharing your words of wisdom. Now I will love to welcome Dr. 𝗏𝗏𝗄𝗏𝗃, Professor, University of School of Law and Legal Studies, GGIPU, as our keynote speaker of Technical Session 2. Dr. 𝗏𝗏𝗃 started her career as a lecturer in Amity University, affiliated from GGIPU, in the year 1990. In 2008, she was promoted as a professor and deputy director and transferred to Amity University. She has teaching and research experience of 14 years. She completed her PhD in Jamia Millia Islamia in 2007, her specialization in the area of capital market and land laws. She has joined the University of School of Law and Legal Studies, GGIPU, on May 21st, 2030. Ma'am, CPJ welcomes you wholeheartedly. Now I request Dr. 𝗏𝗏𝗃 to kindly give an opening remark of the second technical session.
Thank you, Ishmeet, for your kind words.
Thank you.
It's always a pleasure to be here at CPJ. All the participants, fellow colleagues, and of course, the chair of the session, Dr. Rakesh Kumar, my very dear colleague from the University School of Law. It's a pleasure to be here. As Mr. Yugam Chaturvedi put in, that the conference was earlier scheduled for 20th of March 2020, and due to COVID, it got postponed. I must say here that the theme and the relevance of this conference has nowhere diminished. It has actually increased due to COVID times. The whole system, the change, the new normal that has come in has made it very relevant for us to discuss on our family ties, on our family situations, and what changes are required and how we have to face the contemporary times and find out solutions to the new challenges that we are facing. The theme of the conference has become all the more relevant because it's time of uncertainty and we have to cross these times of uncertainty together. And families are the building blocks of the society, and a stable and a strong society can only face such epidemics, challenges, or whatever political or the social situations that come forward. And when I was going through the spiral that the CPJ college sent me with a lot of themes and the sessions which are being held, I found that the papers which were presented or papers that were chosen for all the sessions, they were based on contemporary ideas. The 6 papers in the earlier technical session and also the 6 papers in this session are all very diverse, and we hope that we'll be able to share good views and find out certain situations and find out solutions to them, which we are either already facing or we are tend to face in the coming times. I would not like to take much of your time. We'll start with the technical session if Dr. Rakesh Kumar is already there. Thank you.
Okay, thank you so much, ma'am, for sharing your words with us. Now we are proceeding towards the technical session.
The first speaker is Ms. Richa Gupta.
Yes, ma'am. Now let us start with the paper presentation of technical session 2. I would request to the speaker to please limit their respective presentation to maximum 10 minutes. All the presenters are requested to kindly take note of it.
My greetings to one and all. And it's always very nice to give a presentation that is associated with CPJ because I started my teaching career with CPJ. The theme which I have selected for today is regarding, can you please make me the co-host so that I can share my PPT?
Sure, ma'am. Let me invite our first paper presenter, Ms. Richa Gupta, Assistant Professor from Vivekananda Institute, Delhi, and her title is Home is Not Safe. Ma'am, you are the co-host. Now you can share your PPT.
Smith, I have a question.
Yes, ma'am.
After the presentations, do we have time for question answers, or all the question answers will be taken together in the end? What is Dr. Rakesh Kumar is the chair of the session? What is he to say about it?
Okay, Rakesh sir.
Rakesh ji, kindly unmute yourself.
Although it's after the session only.
Rakesh ji, unmute yourself. Yeah.
Yes, sir. Yes, sir. Yes, sir. I have unmuted myself.
Yeah.
I was just talking to Amit sir. Ma'am, good afternoon. Good afternoon to all of you.
You are not only helpful for other affiliated colleges, you are most helpful for our own college also. We also cannot move without you, Rakesh.
It's my privilege, ma'am.
I mean, question answers together or question answers afterwards, Rakesh?
Together कर लेंगे थोड़ा सा बीच में ही मतलब after the end of the presentation we will go, so continuity will be there.
ठीक है, we'll ask it side by side.
Okay, ma'am. Richa ma'am, please begin.
I hope my screen is visible.
Yes, ma'am, it's visible. You can do it full screen.
Okay.
Yes. Richa ma'am, please start.
Yeah, sorry for the delay. So I'm starting with the presentation. Home is not safe. The topic obviously relates with the concept of domestic violence. Now, this domestic violence, this is not a new or alien concept regarding the Indian society and in fact the world over. This has been like an accepted norm for the last few centuries in our society. And it has always been perceived as a phenomena that there is nothing wrong in these kind of practices. Now, for the first time, the concept of domestic violence was recognized as an evil with the enactment of Protection of Women from Domestic Violence Act 2005. It has been enforced from 17/10/2006 and as it was enacted in pursuance of CEDAW. The act seeks to protect a woman from domestic violence of a person from whom she is or she has been in a domestic relationship. Now, this raises a question that how do we see domestic violence or how do we describe this? So, domestic violence occurs when a family member or partner or ex-partner attempts to physically or psychologically dominate or harm the other. It can be exhibited in many forms, including physical violence, sexual abuse, emotional abuse, intimidation, economic deprivation, or threats of violence. It takes within its sweeps offenses from wrongful confinement to dowry death. Now, why domestic violence is a matter of concern or what are its effects so that we should pay attention to this. The incidence of domestic violence has far-reaching social, financial, health, and psychological consequences, not only for the victim, but at the societal level as well. The consequences on the victim may include anxiety, depression, physical stress, suicidal attempts, alcohol, drug abuse, sleep disturbance, loss of self-confidence and esteem. Apart from this, it also has its effect upon the other members of the society, especially the children. The families having the practice of domestic violence, there the children are more prone to child abuse. The immediate impact on children of victims may include emotional or behavioral problems. They may suffer from poor school performance, adjustment problems, which may sometimes lead to severe consequences like running away from home or getting addicted to drugs, etc. Besides that, the impact of domestic violence also have an indirect cost on the government for being perpetrators of justice or providing for medical treatment of the injured victim, shelter homes, counseling centers. The government has to share the burden. Where a safety net is not provided by the government, many women thus feel that they have no choice but to stay with the abuser. This leads to the societal cost as well. From an international perspective, domestic violence is a universal phenomenon and exists in all countries having diverse political and cultural structure. The extensiveness of the problem of domestic violence does not originate from a particular individual. Rather, it is embedded in values, relationship, and social and institutional structure of the society. Now, coming over to the keynotes, coming over to the keynotes, which or the ambitions with which this act was enacted, and what was actually anticipated that this enactment will serve with. So the key features of this act are that domestic violence, it has got a broader definition and includes not only physical and verbal abuse, but also emotional abuse, and seeks to protect a woman from sexual and economic abuse as well. Here, it would be necessary to appreciate that earlier to this, the concept of domestic violence not formally recognized in our legal system, and a slight recognition was given under the provision of Section 498A, which was mainly concerned with the physical and mental cruelty. There was no cognizance of the sexual abuse or the economic abuse of the victim. Another important feature which this act seeks is that it seeks to protect not only the married women, but any female living under the shared household and is related by consanguinity, marriage, or a relationship in the nature of marriage or adoption. That is, the victim may be a sister, a widow, a single mother. They all are entitled to protection under this act. In fact, our Supreme Court has been generous enough to include a woman living in live-in relationship also. Another worth mentioning feature of this act is that marital rape is an exception to the rape under IPC, but the Domestic Violence Act comes to the rescue of the victim through protection orders. Forced intercourse, forcing to watch pornography, or any act of sexual nature to abuse, humiliate, or degrade, which is otherwise violative of one's dignity, can be taken cognizance under the Domestic Violence Act 2005. Here again, I would like to draw a contrast with the IPC, Section 375, wherein a wife who is above the age of 15 years, sexual intercourse with that wife is not an offense. That means the consent of the wife is not material, that is taken for granted. But the Domestic Violence Act has taken note of the fact, and it has tried to come to the rescue of such women. One of the most important features of the act is again that the women has got a right to secure housing. Earlier, whatever legislation we had, be it in our penal code or under our personal laws, what were the courts were mainly concerned about is about providing maintenance to the victim. But this act has got specific provisions wherein the women's right to secure housing has been acknowledged. Exclusive remedy, then another important feature is exclusive remedy of providing compensation for loss of earning, medical expenses, and loss caused due to destruction or damage or removal of any property for the first time, in addition to an order of maintenance. That is, if a woman is deprived from pursuing his economic activities and earn a livelihood, then that has been taken note of under the Domestic Violence Act. And there are provisions which provides for economic compensation also for causing such loss to the victim. But is the act actually so? Is the act actually so fruitful? We need to do a critical appraisal of the working of the act. Till now, it is more than 15 years that the act has been enforced. And we cannot deny that the domestic violence still persists. In fact, as the keynote speaker was just pointing out, that these issues have been more raised during the COVID times. We have seen several newspaper reports which has been saying without any doubt that there are more and more cases of domestic violence that has been reported during the COVID times. So how has been the working of the Act so far? The Act undoubtedly has been instrumental in creating awareness about the passive nature of the domestic violence and come a long way in realizing the goals of safe homes. But the lacunas in the existing system does not provide the best of the solutions. The incidence of domestic violence still persist irrespective of the education and status, both in rural and urban setup. Even the courts, while taking up such cases, are preoccupied with the notion that it is a civil remedy which is being enforced by criminal law and completely lose sight of the reason why a civil remedy is sought to be enforced by a criminal mechanism. As a result, even the criminalization of the domestic violence has not really helped the cause of the women. Ordinarily, a woman in distress is reluctant to approach the police, irrespective of her educational and economic strata. In the context of the home, emotional ties and tendency to rever family relationships have always discouraged women generally from reporting the treatment given to them in their own houses. It is only after the violence has become unbearable that she decides to register a formal complaint.
Thank you.
Further,
time has been up. Kindly wind up.
Just give me 2 minutes.
Ma'am. Okay, ma'am. Time has been up, ma'am. 10 minutes already have been done.
Then the Act, according to me, the most important feature of this Act was for providing compensation for economic loss. But I have done study over the last few years regarding the judgment that are provided by the courts in domestic violence cases. And I was not able to find even a single judgment wherein the court has taken the steps to provide compensation for economic loss. They are still only concerned with providing the subsistence allowance, not even the decent maintenance allowance, but then they are just providing the subsistence allowance. Forget about the economic compensation. And then the another lacune is that lot more women welfare organizations have been created, wherein which are receiving government aid to mend this cause, but then they have also confined themselves to some stereotype events, that is creating cultural functions and getting media attention. They seldom take any case wherein they take up the investigation of the alleged incidents. So in this scenario, it can be concluded that the provisions of Domestic Violence Act has been undoubtedly successful in creating an awareness regarding this phenomena, but we are really far from realizing the intended goals of safe homes. Thank you.
Thank you so much, ma'am. Sharing your.
Thank you, Richa ma'am. I think I can have some bit of questions.
Yes,
yes, sir.
Ma'am, you have just outlined the various kind of the abuse to which the women are subjected under the Domestic Violence Act, like the physical abuse, sexual abuse, then the emotional or economic abuse, and you also discuss about that here this act also take care of the living relationship, and you also said that here it also provide for the concept of share household, and there's also provision regarding the monetary benefits. And there's also provision for the custody of the children, as well as the safety of the women. But if you see the working of the Domestic Violence Act, it is, as far I still hold the view that it is neither a punitive in nature nor a reformative nature, because there are so many things which still needs to be answered. And the first thing regarding that the definitions of this aggrieved persons and respondent. So what is your take regarding the existing definitions of the aggrieved persons and the respondent, number one? Because domestic violence is primarily concerned regarding the protections of the women against violence. It is not taking care of any other kind of the violence which is continue in the family, number one. Number two, if you see the pattern of the domestic violence, then you will find the persons belonging to the higher state of the society, they are subjected to the more emotional or psychological violence rather than the physical violence. But it is only the persons who are living in the lower state of society, they are more abused to the all kind of the physical violence. So my question is to how the existing law is to be modified to provide protection to the women who are placed in the lower lower socioeconomic profile. And because for these category women, it's very hard to escape from the violence which is perpetrated day and night. So what needs to be done regarding this? Second thing regarding that, this act has also provided for the appointment of protection officers. And the no concrete measure has been taken regarding the appointment. It is only the government official deputed for this purpose. So what is your view regarding the appointment of the protection officers who will provide this kind of the helping hand to the women who are suffering from this kind of the constant abuse?
So the first question you talk about, what about the definition of the aggrieved persons? Of course, I agree with you that the definition may be made gender neutral. Since we are having a patriarchal society where injustice is more caused towards the women, so this act has been framed keeping in mind to improve the condition of the women. But yes, with the changing times, we can look forward to make it a gender neutral legislation. Then your second question was regarding that how the laws should be modified. Here I seek liberty to differ from you, sir. I don't think so that law needs to be modified. I feel like that whatever laws are actually there in existence, they need to be enforced more effectively. The approach of the enforcement agencies, that needs to be changed. I have highlighted one point during my presentation that even the judicial officers lose sight that why this civil remedy is now sought by the criminal method or criminal mechanism, because the civil mechanism was not sufficient. That was not able to serve its purpose. But then the judicial officers, they are also coming from the same patriarchal society. And we can very well assume that they are also not fully without any bias. So they go ahead by trying such cases with the same kind of mindset. At times, an aggrieved woman, or we say that if we make it gender neutral, an aggrieved person, it may be a question of like a life and death. Somebody suddenly thrown out of the house, and the judiciary or the courts will take at least 2 weeks time to give them the protection orders. So I feel that whatever existing provisions are there, they need to be enforced effectively rather than bringing modifications in the existing laws. If you will see the Domestic Violence Act, it is a legislation which takes care of all the kind of abuses, all kinds of violence. But usko recognize तो किया आपने, but आपने उसके लिए remedy जो आपने remedy भी prescribe कर दिया, but offense जहां जिस रास्ते से recognize किया वहां से remedy तक पहुंचने के लिए रास्ता proper नहीं है victims के पास आज भी. There is no clear way for the victims. Then protracted trial, we all know that how many years does it take? And then your third question was related to the protection officers, sir. Sir, I have very closely watched about the working of the protection officers, and it is my heart pains when I have seen the reality that whenever a victim approaches to the court of the Metropolitan Magistrate and a protection officer is appointed, the protection officer being a government servant, corruption being embedded so deeply in our systems, they do not get anything from the victim. Rather, the respondent, they bribe the protection officers and a report is generated in their favor. I have seen the cases where the protection officer has prepared the report and WhatsApped the respondent that, look, this is the report I have prepared and I am submitting in the court. So again, having the protection officers, or maybe having a protection officer who is from some women organization, I feel that this is not helping much. Maybe what is the panacea for this? I really don't know, but I don't think so that the mechanism of having protection officers is actually helping.
I think one thing I just gone through the article. You have also talked about the marital rape, but I think that provision is already being amended by the recent
Yes,
criminal amendment.
Yes, yes.
So
now
the
age has been increased from in fact 15 to 18.
Rakesh,
one more last question.
Rakesh, with your permission, can I ask a question? Richa,
good afternoon.
You do not require any permission, ma'am.
You're the chair of the session, Rakesh. You have
No.
Richa, I wanted to ask, the title is Home is Not Safe. Why did you give a negative title to your article?
Maybe I was influenced by the reports that were coming in the newspaper during the COVID times.
And a small suggestion, Richa, when we as, first of all, law teachers, secondly as females, agar hum hi negatively kahenge home is not safe, then the
Ma'am, sorry, you are not audible.
I think we can move to the. Thank you so much, Richa ma'am.
Yeah,
thank you, sir.
Thank you so much.
My greetings to everyone once again.
Thank you, ma'am. Thank you, Rakesh, sir. Kamal, ma'am will be joining us soon. So let's move further. I will love to invite now the next presenter, Mr. 𝗟𝗍𝗄 𝗏𝗏𝗏, Assistant Professor from Bangalore, and his title of his paper is A Nexus Between Uneducated Child and a Child Labor, State Promises and Administrative Challenges.
Good afternoon, one and all present here. I'm audible to all of you?
Yes, sir, audible. So can you adjust your camera a bit? Yeah. Ma'am has joined us again. So you can share your PPT.
Yeah, sure. Is it showing now, ma'am? Ma'am, you are not audible.
Yes, sir. Yes, you can do it full screen, sir.
Yeah, sure.
Thank you.
So good afternoon, one and all present here. Myself, 𝗟𝗍𝗄 𝗏𝗏𝗏, Assistant Professor in School of Law, Alliance University, Bangalore. And my today's topic of presentation is a nexus between uneducated child and child labor, state promises and administrative challenges. So if we talk about at the introductory level, let's send a child where they actually belongs, that is actually school. Education plays a very vital role, or you can say that a prominent role in one's life. So far as socio-economic growth of a nation is concerned, without education, nothing is to to the globalization, as we are thinking about today's scenario. This research paper entails that how there is a relation between child education and child labor, keeping in mind state action, responsibilities, promises, and executive challenges has ever been faced while upholding these promises and responsibilities to the particular topic. There are always been a number of governing laws, rules, regulation, enactments, statutes with such regard, then why implementation of such laws negate to the objective of this particular great topic, that is child education, why it is to be negating down. Further, if we talk about As per the Child Right Charter, a universal definition of child includes all persons under the age of 14, and 40% of India's population is below the age of 14 years, which is at least 400 million in the world's largest child population. Actually, uneducated child means child who is not even having basic education so far as right to education is concerned, even though it is obviously be provided under Article 21A of the Constitution of India, so far as Part 3rd of fundamental right is concerned. Except then that there is also be directive principle under Article 39E and F. Obviously then that
So
article
it's not 39E.
45.
It's not 39E.
39.
Okay, please.
Sir, it is actually talking about the children are not to be sent for the exploitation. E and F, I think, or F or G, I think, there it is provided. After than that, if we talk about Article 45 is also be taken into consideration. Else than that, there is a duty of a state to send children below the age of 14 years from the 6 years to the particular education institution. So as we can say that our grand norm, that is Constitution of India, is ensuring that child must have to be sent to the school from 6 to 14 years of age. So this is what exactly our Constitution is provided. After than that, state shall provide compulsory education to all children the age of 6 to 14 years in such manner as state may by law determine. With this regard, after 2002, in 2002 Amendment Act, it is to be recognized adding under Article 21, 21A. After than that, 2009 RTE Act came, and with this regard, this particular situation has to be changed now. If we further talk about the child labor, which is expressly stated in our Constitution also under Article 24, prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine, engage in any other hazardous employment. This is the express provision provided in Article 24 in Constitution of India. So if we talk about, even if we having Article 21A on one hand, on second hand, on the other hand, if we have Article 24 and 21A and 24, then why it is to be taken into account in very flourish way, and why these things are negating down the periphery of the actual constitutionality. If we talk about judicial responses, in 1996, writ petition, civil writ petition number 456/1986 on MC Mehta versus State of Tamil Nadu, the Supreme Court India stated that regulating hours for work of children working in non-hazardous occupation so that their working hours do not exceed 6 hours per day, and education for at least 2 hours is to be ensured, and the entire expenses is to be taken or to be borne by the concerned employer. But even after the particular judgment was delivered in 2002, the amendment came into the force and stating that the particular, you can say that the amendment came and state it is the responsibility of a state that all the child below the age of 14 and from the age of 6 are now be sent to the basic education, sent to the school for the basic education. Now, on the other hand, RTE is also there. There must always be some nexus regarding the child education, not to promote them for a labor. It is widely recognized that issues related to child labor and out of school children are both significant global problem. The need of integrated approach to the issues would appear obvious, but in fact, the two issues are often considered quite separately. There are still many national education sector strategy plans in which the issues of child labor is not even be mentioned. There are so many things which are taken into account. There are also programs on child labor that fail to adequately reflect the central importance of the children regulatorily attending the school. It is therefore useful to restate the reason that child labor is a major barrier to reaching the education goal, and importance of the policy and program coherence these two issues. But state is provide effective plans gearing up responsibility with such regard. And there are so many plans is ever been discussed by the center and state government. Some of them are various programs named as Sarv Shiksha Abhiyan, Midday Meal Policy, Rashtriya Madhyamik Shiksha Abhiyan, Girl Hostel Scheme, Scholarship Scheme, National Merit Cum Means Scholarship Scheme, Bal Shri schemes. These are the some schemes which are to be defined by the particular government, taking the view of central government advices, and central government is always be keeping in mind while influencing or executing these particular schemes. These schemes are a boon to the eradicate problem of illiteracy from the India, but well implementation and proper planned administrative execution with regard these schemes are not taken place. Thus schemes like this water down its periphery and objective and the purposes. Further, if we talk about the challenges, there are some administrative failure regarding the implementation of the various schemes that we have discussed in the slides above. Because of the corruption, greed, and scams, widely interpreted laws, regulation are not to be strictly enforced. Maladministration and malpractices and government schemes are also one of the main reasons that these schemes are not as much as effective as could ever be. There should be some promptness of the commitment to the part of the government to implementation of these laws. The poor uneducated parents may not know the importance of the education. So it is duty of the government department, NGO, and other social organization to conduct various programs and activities through which they can educate the people and the parent. If we talk about the hypothesis of this particular paper, it can be said that child illiteracy moves her towards the doing labor. He or she has not been able to understand what is the wrong and right, just because of the greed of any amount of money, poor family condition, and apathy towards them force child to do labor. Research plan, if we talk about, brief literature review has to be done with regard to that. List of research question was examined, and description of methodology. We plan to use answer of the questions. There are some research questions are also framed with such regard, and list of the key source and data to be taken into consideration. If we talk about the conclusion, I just want to get permission from the panel. I want to quote a practical example with such regard. Can you please permit, sir, for the practical example? I just want to quote it out.
This is sufficient, but let me to come to your, because I just had the occasions to go through your articles. And if you see the second paragraph, you have mentioned about the UNICEF estimate about the 115 million children out of the school, 62 millions of them are girls. But it is not clear that you are just giving this figure of the all India basis or the global level, number one. Number two, you have also mentioned that this paper presents the estimate of the child labor in sub-Saharan Africa, but there is no reference of the kind of the literacy which the African people are having. The third thing is that you have mentioned about the India literacy status, and that you have given the 1991 census. Why you have not included the 2001 and 2011 census report? And the fourth thing regarding that, just a minute, you have just mentioned about the various kind of the scheme that was being implemented by the government, elementary level, then the secondary level, then the higher education level. But the most interesting thing regarding that the conclusion aspect, there you have mentioned that there's an inverse, it's just reflecting on the PPT also, there's an inverse relationship between the labor force participant educations. The finding of this study clearly show that the year of schooling of children and their parents decreases the tendency of children to participate in labor force in there. Can you highlight on this particular point? Because there's a lot of deficiency, because if you are giving presentations, you are writing article, then these are the certain basic things which you must have taken care of. Because here the thing is that you have simply just jotted down the kind of the scheme which is available for the various things. But anyhow, just to only come to this conclusion aspect, can you just highlight what you wanted to convey by this inverse relationship?
And I just, sure, sir. And I just want to give some kind of suggestions with regard to also. There is an NGO. I'm just quoting out an example with regard to the conclusion and suggestions only. There is an NGO named called XYZ Foundation, which has found some children in Bengaluru city with forced to sell toys and flowers, etc., beggary and hawking at the street signal. Their fundamental right of Article 21A and 24 are violating with this regard. Therefore, these issues with regard to the fundamental right and human rights mutilate the child's freedom and the dignity. But in the case of, in this particular, you can say that NGO XYZ filed a case before to the Honorable High Court Karnataka with the writ petition number 10096/2020 and directed the Karnataka State Legal Service Authority to propose a scheme for the identification of the children in the city of Bengaluru, making 8 zones in the city where children are forced to sell toys, flowers, etc. in the signal. As per the said direction of Karnataka State Legal Service Authority, enjoins some government and non-government organization, and I am one of the part of that particular organization. And in the government organization, the main objective of this particular scheme is to identify vulnerable children, rescue them, systematically put them in restoration, rehabilitation, as the case may be, create awareness and vigilance in the community. Further, the scheme will outline the responsibility and appointed a city task force committee for the role of authorities to ensure immediate response to the issue, constantly monitor and protection of children in need and care for the protection. The government agencies.
Rakesh's question.
I think you are just because whatever the NGO report you are just putting forward, that is not something very unique with the Bangalore or Karnataka. It is all over India phenomena. But only thing is that there are the certain inconsistencies, because you have just pointed out the Uni-Krishnan case and TMPI, but before that, way back in MC Mehta case, the Supreme Court has already laid down the detailed guidelines, what needs to be done regarding the eliminations of the child and how they have to send to the schools. And in fact, in that case, the Supreme Court itself has directed for the setting of the specific fund, where the employer has to contribute the 25,000, and that money will be used for the purpose of providing education. Here, difficulty is not that regarding the constitutional provisions. We have the specific because under Article 21A, there the state has to take a due care under Article 45. Then is also fundamental duty. Difficulty that the whatever the educational opportunity that is available. Here the socio-economic profile of the poor people are such that they are not in positions to provide the children, because they are just providing the helping hand for the earning their livelihood. So here the systematic reform is required, not in the form of the just providing this kind of thing, but here the concerted effort is required in the form of the just pushing the children to the schools, number one. Number two, some kind of penalty has to impose on the parents if they are not sending their children to this way. If these kind of the two small measures are taken by the government, then definitely it will go a long way in improving the literacy levels. And once you are having the literate population, then that case all kind of the issue can be start falling step by step. Thank you, sir.
To what you are saying, Rakesh, it is not illiteracy of children. It is illiteracy of parents that is forcing children to work as laborers. It's not illiteracy of children. They're too young to understand what illiteracy itself is.
Actually, yeah, exactly. The particular thing is that, and also I can take the example of medical treatment with regard to the polio eradication, how the things is to be eradicated with respect of that.
That is a different aspect. Okay, thank you so much.
Yeah. Okay, sir. Thank you so much. Yeah.
We can move to the next.
Thank you so much, sir, for sharing your deep knowledge with us. Sir, आप अपनी PPT close कर सकते हैं. Thank you. Now moving further, I will love to invite our next presenter, Ms. Astha Bhatnagar, Assistant Professor at IIMT Karkadoma. Title of her paper is Transgender Right in Ancestral Property as well as Male Liability.
Thank you, ma'am. Thank you so much. Good afternoon, all the dignitaries and my dear friends. Good afternoon. May I take permission from the chair? May I present my paper?
Yes, Astha, you can proceed, please.
Thank you, sir. Thank you, ma'am. Is it visible?
Yeah, it's visible.
Thank you, sir. Good afternoon, all the dignitaries. Before I start my presentation, I just want to discuss one thing, that is, we have so many rights under so many laws. If we take about family law, we have right by birth as well as liability under Section 6 of the Hindu Succession Act, 1956. Only male have right, but after amendment in 2005, female also have right. But my question is that, what about the transgenders? They also born by mother womb. So they have right in the ancestor property. And if we take Mitaksha family, that boy or as well as girl have right in the ancestor property under section 6 of the Hindu Succession Act. So why we are not counting as a transgender have right under the ancestor property under section 6? If we talk about transgenders, that they also born in the family, and they born as a Hindu family, but they don't have right. If we talk about equality, so they have also same rights under section 6 of the Hindu Succession Act, but because the gender is born as a third gender or some other gender, they don't have right in the Hindu succession in the ancestor property or under the Hindu Succession Act. I'll start my presentation. My presentation topic is transgender's right in inheritance property as well as male member liability towards his parents. India has been the land of the discrimination for women and transgenders against its male counterparts since its history until now. The societal practice prevalent in those days, like sati pratha, prohibition of widow remarriage, etc., shown transgender in India living status. I'm showing some glimpses through my PPT.
Aska, make it full screen, please. Make it slideshow.
Okay.
ये जो कप है ना, कप की तरफ वहां पे क्लिक करो वो। हाँ,
these are the glimpses, the stats of the transgenders Indians living status. Now, the preamble of the Constitution says that everyone equal in the eye of law. We follow this article 14, that men and women both are equal in the eye of law. But why not transgenders? After 2016, the NAS Foundation case give a decriminalization of the transgenders, but the transgenders have no right under section 6 of the Hindu Succession Act. That act give by birthright. By birth means I don't know what I am as a man or female or a transgender, but I have right at the time of birth. So why the transgenders have no right in the Hindu Succession Act section 6? The date of the commencement of the Hindu Succession Act is 2005. That act gave both the same right as a male or a female. By birth become a co-partner in her own right in the same manner as the son. She shall have the same rights in the co-partner property, but no right of transgender. This is my question through my paper. Where is the right of transgenders in inheritance property? Because no one know he is a male or she is a female, because doctor was not disclose the gender before birth. This act does not focus on daughter only, but also the liability of the son, grandson, great-grandson, and the right of the transgenders for recovery of any debts due from his father, grandfather, or great-grandfather solely on the ground of the pious obligation under Hindu law. This law aims to remove all the inequality and discrepancy that exist in the old law, and I just want to discuss about the transgenders' rights in the ancestor property. They have right or not? If we talk about male and female, so they have right under the so many laws. But if we talk about the transgender, there is no right. Where is their right? And this is also one glimpses that 2011 data. This is total transgenders rate, and this one is 2020 data. Transgenders. Next, when a child is born, a doctor say it's a boy or it's a girl. But what about the third gender? Assigning someone's sex is based on biological chromosomes and hormones. But a person's gender identity, the inner sense of being male, female, or both, does not always match their biologically. Transgenders people say they were assigned a sex that it isn't true to who they are. Many people have assumption about what it means to be transgender, but it isn't about surgery or sexual orientation or even how someone dressed. It's how they feel inside. We know that transgenders are decriminalized, but they don't have civil rights as well as criminal rights. If we talk about ancestor property, they have also right in the ancestor property because they are born in the Mitaksha school, and they have right in the in his or her ancestor property because they born in the family. The Williams Institute say there are nearly 7 lakh people living publicly as transgender in US. Each one of the unique and their journey are personal. Some says they are the opposite sex of what they were assigned at birth. Some people they are both male and female, still others don't identify as either gender. This is the total born in 2020 488 transgender born in 2020 488, Uttar Pradesh 137, Andhra Pradesh 44, Maharashtra 41, Bihar 41, West Bengal 30, MP 30, Tamil Nadu 22, Odisha 20, Karnataka 20, Rajasthan 17. Overall 488 born in 2020 transgenders. In India, inheritance of property is governed by personal laws of the respective religion and community. These laws distinguish as per the gender in 2 categories, that is male and female. Transgender persons need to be put themselves in any one of these categories in order to come within the ambit of the inheritance of law. Hindu Succession Act 1956 as well as 2005, which govern Hindu from the purpose of inheritance of both joint and separate property, only recognize male and female as a subject matter of the property right. The term used in the act such as male, female, daughter, son, etc. are restricted to the binary gender identity. The act does not talk about the transgenders or any other person with the different sexual orientation. Mostly such person is outcasted from their family and has no say in their family property or in the property of their parents. The family is violate of Article 15 of the Indian Constitution, which prohibit the discrimination on the ground of sex. The term sex is not just limited to biological sex as male or a female, but also include a person who does not recognize himself as a male or a female. I just want to conclude one thing, that transgender have also rights in the civil law because they are born in the Mitaksha family. Transgender community discriminate on the ground of employment, gender identity, and various other legal rights, of which inheritance of property is discussed in the paper. The law for inheritance in India are subject to binary gender identity, and therefore transgender is not included in it. According to section 377 of the Indian Penal Code 1860, anal intercourse between the transgender is criminalized. After the NAS Foundation, it is decriminalized because lesbian and gay have decriminalized. They have right to live their life with fully. Thanks. Ultimately, I just conclude my paper, that is, in the cases, no discrimination on the basis of transgender ground, and we give to them same liability, same rights, because they are born under the Mitaksha school. If he or she and third gender have same mother and father, so the only one child have liability. This is also wrong. Both the child have same liability and the other have no liability. This is wrong. Transgender have same rights and liability under section 6 of the Hindu Succession Act. Thank you so much.
Thank you so much, ma'am.
Thank you.
Sir, Rakesh sir.
Yes, Asta, thank you very much for giving your presentations. But if you see your presentation, you have simply focused on that the transgender has been not given the right with respect to the property. And if you see the recent judicial approach, just last year, month of November, Supreme Court has come out with a very historic verdict where the right has been given to the women with respect to the all kind of property, except the condition that it will not going to reopen the partition which is already affected. And you might have seen the Nalsa judgment also. In that judgment, 2014, the Supreme Court has distinctly recognized the definite right of the transgender, including their entitlement to the reservations which may be provided by the government. So I think that aspect you have still not covered, because there are the distinct recognitions of the right of the transgender. And other thing which you have highlighted in your presentation regarding that who will be considered as the transgender. So whether if you see the Nalsa judgment, particularly if you see the approach of Justice Radhakrishnan and Justice Sikri, then you will clearly find the distinct contradiction in the approach, because here the main issue as to whether the transgender has to be defined on the basis of the self-proclaimed status, or it has to determine on the basis of essentiality test. So that issue you have not addressed, and if you go through your paper, then you are still in the 2016 bill. But back in 2019, the specific act is being enacted by the Parliament for the purpose of protecting the rights of the transgender persons. So I think you need to just modify this in view of the latest judgment, as well that the various provision which has been provided this 2019 act. And apart from this, you also required to revisit the status of this section 377. So these are the certain things which require the urgent attentions. But as far as the conclusion aspect is concerned, still you have not touched the aspect as to how to determine who will be transgenders, how the valuable resources of the state has to be distributed, and what are the different kind of the facility amenity that has to be provided, what are the difficulty in the implementations of those. So you have just tried to not try to address, but you take care of these things in the future regarding this area. Thank you so much.
Thank you so much, sir. Thank you, sir. I will definitely.
Only thing that I would like to add, Astha, is that there should be a certain flow. You should always start making a research question and then start writing a paper. It should not be a compilation. It should be a flow that what you are arriving at. You took a very good topic that, okay, they have not been given rights, but you have not found out what suggestions you can give, how we can implement it. Okay, try and analyze it critically.
Thank you, ma'am.
Thank you so much, Astha ma'am. Thank you so much, Kanwal ma'am. Thank you so much, Rakesh sir. Now moving further, we'll have to invite our next presenter, Mr. 𝗤𝗵𝗵𝗶 𝗪, Research Scholar, University of Law and Legal Studies, GGIPU. His title is of paper, Navigating Through the Troubled Waters and Analysis of the Transgender Person, Protection of Rights Act under 2019.
Hope I'm audible.
Yes, sir, you are audible.
Good afternoon to the respected dignitaries and fellow participants in this conference. My name is 𝗤𝗵𝗵𝗶 𝗪, and I'm pursuing my PhD from University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University at the moment. The title of my topic is Navigating Through the Troubled Waters, an Analysis of the Transgender Persons Protection of Rights Act 2019. Under the present research or under the present presentation, the researcher would like to contemplate and delve into the detailed nuances of the Transgender Act 2019, which received the presidential assent on 5th of December 2019, by pinpointing pluses as well as the minuses of this particular legislation. Let's move on to the hypothesis of the present research. The hypothesis of the present research is threefold in nature. Firstly, the definition of the term transgender has been plagued with hazy and obscure ideas in India. Secondly, the Transgender Persons Protection of Rights Act 2019 goes against the basic canons of LGBTQIA+ community. And lastly, but certainly not the least, the Act has plethora of problems which need alteration or modifications. Let's move on to the objectives of the present research. They are also threefold in nature. Firstly, to analyze the definition of the term transgender people and distinguishing it from transsexual people and intersex people. And secondly, to analyze the Transgender Persons Protection of Rights Act 2019 and finding out the loopholes in the same. And lastly, but certainly not the least, to suggest adequate modifications in the present act, thereby targeting the existing problems and maladies. Let's move on to the definition of the term transgender people. There has been a dichotomy with respect to the definition of the term transgender people across the globe. However, sociologists and psychologists who have distinct opinions regarding the same, but out of the entire discussion, one concrete thing has emanated out of the same, and that is transgender people feel that they are trapped in the wrong body structure. This implies that if a person who's biologically born as a boy, but intends to become a girl, and he feels that he's trapped in the wrong body structure, then that person would be labeled as a transgender person. But it is very saddening to note that this term has been incessantly confused with transsexual persons and intersex person. I would categorically classify the same. So this slide talks about the categorical classification of the LGBTQIA+ jargons used under the present research. First is the transgender person. As I explained in the preceding slide, that a person who's biologically born as a boy but intends to become a girl, so there is non-concurrence between the mental gender and the physical gender of that person, and that person would be labeled as a transgender person. But then what is a transsexual person? A transgender person who goes a step further in that direction and tries to surgically change his body in order to become a girl, which he intended to do so, would be labeled as a transsexual person. Under this, the person deliberately goes under the knives so that his mental gender coincides with the biological gender. And lastly, the third category, which has been continuously labeled under the domain of transgender people, is the intersex. A person who's born with varied form of genitalia and cannot fit into the definition of a boy or a girl biologically would be labeled as an intersex person. Now, an interesting thing to note at this juncture is that United Declaration on Human Rights 1948 under Article 2 states that every person shall be given those rights which have been enshrined under that particular declaration, irrespective of race, color, religion, caste. However, alternate sexualities has been kept out of the purview of the present declaration. Even ICCPR and ICSCR also suffer from the same lacuna. Let's move on to the analysis of the Transgender Persons Protection of Rights Act 2019. The right of legally recognizing the transgender people as the third gender was given in the Nalsa judgment. We are very much aware about the same. But the government did not come up with any specific legislation to protect the rights of the transgender people during this time. However, new legislation of 2019, which received the presidential assent on 5th of December 2019, talked about the protection of rights and promotion of transgender community and was a milestone in the history of transgender movement. Now, we would like to go on to adopt the Pollyannism approach, wherein I'll be analyzing the positive aspects first and then be on the critique side. First, Section 3 talks about the provisions of equal treatment of transgender people by absorbing them in the mainstream of the society. It is not a hidden fact that transgender people are often subject to drudgery and discriminatory treatment by the rest of the society. So this provision itself ensures equal treatment. Second, Section 8 talks about promotion of welfare schemes which are sensitive and non-stigmatizing. Section 9 talks about equal standing in terms of educational as well as job opportunities. Section 15 talks about the facilitation of health measures like creation of serosurveillance centers for HIV-affected transgender people. As we all know, transgender community is vulnerable to human immunovirus, so therefore these centers are the need of the hour. And lastly, Section 16 talks about the creation of National Council of Transgender People, which promotes and protects the rights of the transgender community. Now, these were some of the positive points which were highlighted under the Act. Now I shall be moving on to the problems with the problems associated with the Act. First is the inadequate definition clause. As explained earlier in the preceding slides, the definition or the interpretation clause of the Act is highly hazy and inadequate. It does not cover the terms transsexual, intersex, transvestite, even cisgender for that matter. So this ambiguity always persists. Second, fallacies in Chapter 3 of the Act, arbitrary procedure of the gender assignment. Now, Under this particular legislation, it has been categorically stated that a person is going to be labeled as a transgender person, but as per the provisions of this particular statute. This has been categorically stated in Section 4 of the Act. Now, Section 5 gives an uncanny discretionary power on the district magistrate to label a person as a transgender person in consultation with the chief medical officer of the in the nearby hospital. Now, the point to be put across is that this arbitrary procedure of imposing gender on somebody is unknown and alien to all of us. Now, third is the gender certificate issued under Section 7, unlawful and unethical. This highly illicit gender imposition by the district magistrate on a person is actually, it goes against the canons of Article 14 of the Indian Constitution. Now, no person of the heteronormative culture, no person of our culture is actually forced to take up sexuality or sexual preference. So why do LGBTQIA+ community people have to face this? Then third is creation of unwarranted rehabilitation centers. Section 12 clause 3 talks about the creation of rehabilitation centers, but we already know that transgender people have their self-chosen families and also live in guru-chela relationships, so they do not need those rehabilitation centers. Fourthly, complaint officer under Section 11, he's a rubber stamp. There is no enforcement agency to ensure the enforcement of the provisions of this particular act, and therefore the complaint officer position mentioned under this particular act is a rubber stamp position. Lighter punishments. It is very disheartening to note that punishments with respect to similar offenses have more weightage when it comes to IPC, but they follow a very rigorous method when it comes to transgender people. So say, for example, if a transgender person is forced to do bonded labor, that person will be charged with 2 years of imprisonment. However, the IPC provisions are absolutely different on the issue. So this categorical discrimination needs to be done away with. Lastly, limited representation from the transgender community. Second last, this talks about that Section 16, Clause 2, subclause 3 talks about that only 5 people from the transgender community can form a part of the National Council of Transgender People. Now, across the country, there are so many transgenders living at the moment, and only 5 is definitely, an aspect of limited representation. Lastly, lacking affirmative action approach. In the Suresh Kaushal judgment, G.S. Sanghvi pertinently pointed out that the community is minuscule minority. So if a particular community is facing the realms of a minority, there has to be an inculcation of affirmative action so that they can be protected against the continuous drudgery and discriminatory treatment. Now, let's move on to the conclusion and suggestions. The transgender people have always been targeted because of their different outlook towards life. The problem with the entire research which I have done is that the basic tenet of the ideology of the LGBTQIA+ communities, they are non-conformists, they are non-binary. They do not like to be gender labeled. Now, when you start labeling the gender, of course, it goes against the entire canons of the LGBTQIA+ community. Again, terms like cisgender, intersex, transvestite, they have not found adequate consideration, while drafting the law. So these technical jargons should be explained under the domains of the Act so that proper schemes could be drawn up. And lastly, I would like to conclude by saying that, this particular legislation did give a moral boost to the community, but the way its provisions are drafted, it actually has defended the fundamental premise of the Act itself. However, a judge who has been recently appointed as the judge in Assam, 𝗬𝗏𝗏, she has filed a complaint again, or she has filed a case against the constitutionality of the Act, and the Supreme Court's view on this particular issue shall lay down the future course of action. Now, I would like to open any question or clarification on the issue. I will open the panel.
Thank you so much, sir. Rakesh sir, Kanvi ma'am.
Amen.
So you want to ask anything?
Okay, Vinayak, you have just highlighted so many things, and you also said that the kind of definition of the transgender which has been given,
yes,
that is not in consonance with what the transgender people like,
yes,
or what they desire. but the very definition of the transgender which was given and the intersex, these two things, what are the source of the things which we have quoted? Because it is the part of the judicial pronouncement, or it is the claim which has been made by the people of the transgender community, number one. Number two, you have also talked about the gender assignment. As per the power of district magistrate is concerned, he is merely nominating authority, the notifying authority. He has to act on the advice of the medical officer. The medical officer has certified. Then that case, he will notify the person belongs to transgender or not. Number two. Number three, you are also objecting regarding the recognition. Earlier, there was issue regarding the non-recognition of transgender. It is only after the NALSA judgment 2014. Here, the court has gone to the extent of giving them a status of the third genders, number one. And apart from giving that, they have also imposed the obligations on the state that they have to also recognize the socially and economically backward classes. So they will also be eligible for the affirmative programs. But these are the things which are already made. So you have the objection regarding the recognitions of the transgender by the state. But earlier the issue was that there was issue of the non-recognitions. So now that issue is being addressed. Regarding that the affirmative action program, you are saying there is no affirmative action, but the guidelines is very much clear that the state has to provide the benefit of reservations to the people of transgender. But since you have also dissected other provisions, but my question is again whether it has to determine on the basis of the self-proclaimed status, or it has to be determined on the basis of essentiality test or biological test, because there's a apparent dichotomy in the approach of Justice Radhakrishnan and Justice A.K. Sikri, and both are moving to the extreme directions. Here the Radhakrishnan is saying that that is self-proclaimed, Sikri is saying no, it has to be biologically determined. So what is your view regarding this, and how you will reconcile this contradictory approach?
Yes, sir. So there are a lot of questions, so I'll answer them one by one. So the first question in which you actually asked me the source. So the source, I have tried to gone beyond the barriers of the law, and I have actually gone through various sociological and psychological materials. So say, for example, and it is directly linked with the fourth question as well. That is, what is the status? What am I seeking for? Self-proclaimed status or the given by the law? So the point to, here to be noted is, or what I want to bring home is, so LGBTQI members or LGBTQIA+ community itself thrives upon a basic fundamental principle, that is non-conformist and non-binary. So say, for example, I am a part of the heteronormative society, right? So
it means if this kind of recognition is given to it, will not lead to the anarchy in the system and the society. If everyone starts claiming they should be given this status, they should be given that status. So whether the law has to be modified, or law has to respond to the societal needs as per the aspirations and desire of the individual, or as per the norms of the society.
But sir, at least law has to work in close synchronization with the societal concerns. Because sir, if a community is saying that, I do not believe in the gender stereotypes, I do not want to be labeled as a person. So see, psychologists and sociologists across the globe have time and again pinned down this fact that, transgender, sir, agar aap dhyan se dekhen, the definition in the act itself talks about that a person becomes a transgender person once that medical, thing has been done. But under the normal realms, under the sociological realms, a person, even if he feels to be, even if he feels that, he belongs to a different gender type.
Personal perceptions, personal feeling, in my view, should not be considered criteria as far as the sharing of the valuable social resources of the state is concerned. When the state is giving its definite mandate regarding providing the rehabilitation center, providing the medical facility, and as far as the penal the provision is concerned, here the police is already having the specific responsibility regarding the taking care of the any kind of discrimination that is being practiced. So in that case, what you are asserting is that is something maybe the view of some of the activists, but as far as the technical legal view is concerned, it is something is totally in contradiction what you are saying.
But sir, what I'm saying is that, we can't be forced upon something we are not. So say, for example, if I belong to that community, I should not be, labeled as a person just because I have to undergo a procedure. So the thing is, even if you are saying that, legal technicalities have been missing here. So, sir, I want to make a point here that, actually the word of transsexuals and intersex can also be added. So that is what my entire research is premised on. I'm not saying that, the definition given by the act is wrong, per se is wrong. But what I'm trying to say is that, even the definition might be right, but there are certain alteration modifications which are needed because, sir, see, the entire fundamental tenet of the community is that they do not conform to basic standards of the society. If we are forcibly, sir, हमें उन्हें mainstream में लाना है, but that does not mean we have to drag them to the mainstream society. We have to organically let them come in the mainstream society, and that is why all these terms which they acknowledge, which they appreciate, I think so. That is what I'm saying. This self-proclamation test should be, even the rules which recently came in the year March 2020, they also didn't acknowledge the self-proclamation test. So the point is, अगर हम किसी पे sexuality impose कर रहे हैं,
okay, last question. Okay, last question.
Yes, sir.
Then suppose somebody come forward say that since now the government is providing the reservations benefit, so
yes,
let
sir.
him to proclaim that he is a transgender.
Yes,
so once he will claim he will declare himself and then he will claim the benefits.
Yes, sir.
So
absolutely.
What will happen to the status of the entire community? Whether they will have this distinct identity or their identity will be cornered by somebody else.
Sir, I'm absolutely agreeing with you on this. I'm not saying that the law of the land or the legal nuances which have been, laid down are wrong. But what I'm trying to say is we are kind of marginalizing a certain section of the transgender community and expecting them to become a part of the mainstream society.
I think you have to, when you can give the argument, but the thing is that here you have to also appreciate the concerns of the judiciary and the legislative approach. Because here the entire effort in just to bringing them in mainstream, providing them the kind of the identity and self-respect, and this is what being done by the Supreme Court in giving the very voluminous guidelines what needs to be done for just assimilation. But once you have been given recognition, here the basic thing is that once they are being assimilated, they have been given the set of the rights, then they can. But the thing is that those things have gone in background. And the vocal sections of the transgender are coming forward and they are saying that they should be given the each and everything and they should have the right to decide what will be their status. I think this kind of the right is it is nowhere recognized anywhere in the world, not of any of the international instrument, but it is something which has been desired. So there has to be certain balancing between what is the reality and what they are just aspiring for.
But Rakesh, sir, even if we go on to the sociological jurisprudential aspect.
Later, we can have the discussions later on. I think there are the other presenter also. I think ma'am can wind up on this thing.
Yes, ma'am.
We can talk it later on. I cannot be the judge in my own cause. You only mark him, your marks will be doubled. That is it. I will recluse myself. In my scholar, no point na कि मैं अपने केस में खुद जज बन जाऊं. Let's come to the next one.
Okay. Thank you so much, ma'am. Thank you so much, sir. Thank you to the presenter. Now moving further. Now I will welcome my Mr. 𝗂𝗏 on the behalf of Ms. Ritu Kumari, research scholar of GPS Women University. He will be presenting the paper and the title is Domestic Violence, the Dark Truth of the Society. 𝗂𝗏, sir. 𝗂𝗏, sir, I am audible.
Yeah, you are audible.
Yes, sir. So kindly
make me co-host so that I may
share.
You are
co-host. You are already co-host.
Okay, thank you, ma'am.
Yes, sir.
Let me share, ma'am.
Yes, sir. So you can double click on that now.
Okay, ma'am.
Yes, so now you can do F5 and make it a full screen. Slideshow, full screen. the slideshow पे click करके you can yes. Thank you.
Good afternoon to the chair, Mr. Rakesh sir, and the keynote speaker, Ma'am Kawal ma'am. My topic is the domestic violence, the dark truth of the society. It has been authored by Ms. Ritu Kumari, Research Scholar, Department of Law, BPS University, Women University, Sonipat, and myself, Abhinav Kumar, Research Scholar, Department of Law, Central University of Haryana. So, to begin with, I would like to quote Karl Marx, who has stated that women are the only exploited group in history to have been idealized into powerless, unquote. In India, as several different components of the globe, the patriarchal structure legitimizes men over girls, son over daughter, father over mother, husband over wives, so on. She is neither safe in the outer world nor within the four walls of her own. It is the irony that they are tortured by their saviors and benefactors. This denial of the basic human rights in the grab to culture practices, norms, and misinterpretation of the religious texts, it has become a harsh reality that needs reformation. I would like to highlight the definition of domestic violence. The Webster's New Concept Dictionary defines violence as toil of any physical force as an example of violent treatment or procedure, profanations, infringement, outrage, assault, strength, energy, activities displayed or exerted, when physical or damaging actions or force. The Chambers 20th Century Workbook describes violence as excessive or unjustifiable use of force. Oxford Workbook defines violence as a behavior involving physical force supposed to harm, injury, or kill. According to reference of Book of Crime and Justice, violence may be a general term concerning all kinds of behavior, either threatening or actual, that leads to the injury or destruction of property or the injury or death of individual. As per Black's Law Dictionary, violence suggests the unjust or unwarranted use of force, typically accompanied by fury, vehemence, and outrage, physical force unlawfully exert into the intent of to damage. Thereafter, I like to highlight the concept of domestic violence. Domestic violence is a violent victimization of a girl at intervals, the boundaries of family, typically by men. Violence is a majority of cases violence against ladies by the members of house wherever she resides. It will be the husband, his folks and siblings, or the other residents. World Health Organization has expressed or coveted latitude for the action which will cause physical or mental agonies to ladies. It happens behind closed doors and is mostly oftenly denied by the terrible ladies. World Health Organization also victim of violence. Thereafter, I like to highlight the types of domestic violence. There are extensively three types of physical domestic violence. There is physical abuse, sexual abuse, and marital rape, and third is the emotional abuse. I would like to highlight the physical abuse. Physical abuse is the abuse involving contact meant to cause feelings of intimidation, pain, injury, or alternative physical suffering or bodily hurt. It includes hit, slapping, punching, knocking, pushing, burning, and alternative sorts of contact that leads to physical injury of the victim. Thereafter, I'd like to move on to sexual abuse and marital rape. Sexual abuse in any scenario within which force or threat is employed to get participation in the unwanted gender, coercing an individual to have interaction in gender against their can, though that person may be a significant other or intimate partner with whom according sex has occurred, is associate act of aggression and violence. The third is emotional abuse. Emotional abuse, also known as psychological abuse or mental abuse, will embarrass, demeaning the victim in camera or publicly, dominant what the victim will and can't do, withholding information from the victim, deliberating, doing one thing to form the victim feel diminishes or embarrassed, analytical the victim from friends or family, implicitly blackmailing the victims by harming others once the victim expresses independence or happiness, or denying the victim access to cash or different basic resources and requirements. The third, which I like to highlight, that some of the different forms of domestic violence. UNICEF reports on progress of nation released jointly by the Government of India and UNICEF says that more than 60 million women who should have been alive today are missing. Responsible factors are for resides of domestic violence to dowry, death, and physical assault. Determinations starts even before women's and born continue to exist and formations. I would like to highlight the cause of domestic violence. Domestic violence, there are various causes of domestic violence. First is the gender inequality, cultural factors, psychological factors, lack of awareness of their rights, general social belief of women's subordination, poverty, alcoholism, state of frustration, poor role modeling, depression, lack of money, lack of employment. Other causes of domestic violence are jealousy, behavior, social stress, mental illness, marital conflict disorder. Third, I would like to highlight the consequence of domestic violence. Impact on the victim himself or herself, and also the family, impact on the society, and also the impact on nation's growth and productivity. The effect of the victim has been more subcategorized for the ladies, men, kids, and olds. I would like to highlight the ways to prevent the domestic violence. First of all, I have highlighted 3 ways: legal enforcement, counseling of a person affected, counseling of offenders. Firstly, for the law enforcement, in 1983, domestic violence has recognized as a specific criminal offense by introduction of Section 498A into the IPC. This with the purpose of forcing the woman on her relatives to give some property. Harassment because the woman or her relatives is unable to yield to demands for more money or does not give some property. The punishment is imprisonment for up to 3 years and fine. The complaint against cruelty need not be lodged by the person herself. Any relatives may also make the complaint on her behalf. The second thing is the counseling of person affected. Due to the extent and prevalence of violence in relationship, counselors and therapists should access every client for domestic violence, both experienced and perpetrated. If the clinical is seeing a couples counseling, this assessment should be conducted with each individual privately during initial interviews in order to increase the victim's sense of safety in disclosing domestic violence in the relationship. The third is the counseling of offender. The main goal of treatment for the offenders of domestic violence is to minimize the offender's risk to future domestic violence, whether within the same relationship or a new one. Treatment of offenders should emphasize minimizing risk to the victim and should be modified depending on the offender's history, risk of reoffending, and criminological need. It has been demonstrated that domestic violence offenders maintain a socially acceptable facades to hide abusive behavior, and therefore accountability is the recommended focus of the offenders treatment program. Later, I like to conclude, despite efforts made by the various sections of the society and government to curb the menace of domestic violence against women, there is a rise in domestic violence. We can also have, when we have gone to the lockdown period, there was reports came in the newspaper wherein an increase in the cases of domestic violence has been reported, to which the National Commission for Women has taken the action. This can also be curbed by the domestic violence can be curbed by educating women about her rights, community screening for domestic violence, providing adequate assistance to the victim by offering safe shelters, crisis intervention, advocacy and education and prevention program, provisions of strict laws and punishment for the offense of domestic violence. To conclude, it is therefore necessary that every strata of society must contribute to ensure the violence-free life for every woman. It concludes my presentation, sir.
Thank you so much, sir. Rakesh, sir, Kanwar ma'am.
𝗂𝗵𝗹, the title of your research is the domestic violence, the dark truth of our society. But
Yes, sir.
Throughout presentation, you have primarily focused on the violence against the women.
Yes, sir.
And if we see your research paper, then only you have highlighted the types of the domestic violence and the factors which are responsible for the domestic violence. You have not given any clue or references what kind of legislative effort is made in these directions, what are the approach of judiciary, and what kind of the administrative mechanism has to be set up to check up the various dimensions of the domestic violence. So without, in the absence of this domestic violence Act 2005, or in the absence of the judicial approach, I think it's a very half-hearted attempt regarding the papers. And the other thing is that in the entire paper you just have mentioned the total 5 or 6, 7, 8 or 9 footnotes. So that itself also reflecting the lack of sincerity on your parts. So I think you need to take care of the kind of the legislative provisions we are having, and apart from and when you are mentioning about the various causes, it is everywhere available that the physical, social, economic, but you have to decide how the social factor are contributing towards the domestic violence, how the educational achievement or the status in the society, that is also contributing. So these are the things which you need to dissect.
Sir, as per the current scenario, the law is very adequate one, but the implementation of the law
without going to the provision of domestic violence, you cannot make this kind of generalization. The law is inadequate. The adequacy, inadequacy, you have to decipher from the citing the provisions and giving argument how this provision is deficient.
So definitely
entire research you are just only in the abstract. Abhinav, in abstract you have just mentioned one place, direction like domestic violence to are passed by the parliament to handle the cases related to domestic violence. Apart from, there is no reference of that. So without citing the legislative provisions, or without going through the interpretations, you cannot say that the law is inadequate. You have not discussed about the law, then how you are making this kind of general assessment?
Sir, I am not stating that law is inadequate. I am stating that law is adequate, but there is a lack on the part of enforcement of the laws.
ठीक है, मैम आप कुछ पूछना चाहेंगे? मैम,
I find in the whole paper you have not substantiated whatever you are claiming.
Yeah, it's a lack on my part, ma'am. It's a lack on my part, ma'am.
And see, when you write psychological perspective, or you're writing something social, or you're talking of counseling, whatever things you're talking of, they should be somewhere linked with law. Legal position is nowhere linked with the sociological position or the psychological position. So take care of this.
I will take care of it in the future, ma'am. Thank you, ma'am.
Thank you, sir. Thank you, ma'am. Thank you to the presenter. Now further, I will have to invite our next presenters team, Ms. Tanya and Ms. 𝗔𝗵𝗄𝗏. They both are the students of BBA LLB WIPS Pritampura, and the title of their paper is A Perspective That Matters, Same-Sex Marriage.
Hello, am I audible?
Yes, ma'am, you're audible. Welcome.
Could you please make me the presenter?
Yes, ma'am, you're already a co-host.
Okay, thank you so much.
Abhinav, sir?
Yes, ma'am, I'm leaving.
Yes, sir. You can stop the screen sharing. Thank you, sir. Ma'am, please proceed.
Is my screen visible to everybody here?
Yes, ma'am, it's visible. You can do it from the beginning.
Sure. All right.
Fine, ma'am.
If the chair permits, the researcher would like to start.
Please start.
Thank you. Thank you, ma'am. Marriage is the very fundamental notion on the basis of which the society's prodigal nature and its progeny has been developed. As an institution, it is not just within itself, but is ensnarled with many other factors like political, social, psychological, and legal. Good afternoon, everybody. My name is Tanya Karanwal. I'm a researcher. I, along with my co-researcher, 𝗔𝗵𝗏𝗏 Bhatia, are going to present our paper titled A Perspective That Matters, Same-Sex Marriages. By virtue of this paper, we attempt to answer the claim that the changing the components of marriage would radically change the structure and purpose of marriage in the negative. The researchers herein attempt to bridge the gap between religion, public policy, and social norms. Now, to begin with, it is extremely impertinent to state that what marriage is exactly in its very real sense. Now, all of us here might be aware of the terms used to describe marriage as sacrament, as a contract, as indissoluble, and all of which are marching towards the natural institutionalization of marriage. However, marriage is also regarded as a primary aspect, the primary basis for procreation and the production and maintenance of children. Marriage has been divided on the basis of on many aspects, particularly pertaining to places, religion, and origin, and on the basis of the same, they have been categorized into many fields like polygamy, polyandry, levirate, hypergamy, after death marriage. However, the researchers here have restricted themselves to the very aspect of same-sex marriages. Now, if I begin to speak about same-sex marriage, it has to be firstly understood that this is something which may deem to be uncommon since the ancient time. However, that is not so. The Greeks were the first ones to bring out a document that explicitly spoke about the same-sex marriages. Now, there was though an extreme denial of the very aspect of homosexuality. However, if we go and look back to the proto-industrialization period, we see that it has been highly accepted in the lower classes. However, the upper classes deemed it to be immoral at that time. If I restrict myself to the Hindus, then it will be seen that the scripts like Manu, Smriti, Upanishads, the Kama Sutra have all aspects of homosexuality. Also, a report established that the sannyasis at the time engaged themselves in homosexual activities because they were not permitted to get married to whoever they wanted to get married to, and it is not, the aspect is not as uncommon as it seems to be, because out of around 1500 animal species, the aspect of homosexuality is found in almost 450 of them. Now, as the researcher already stated before, that the aspect of marriage is not alone within itself, the researcher would like to move towards the next perspective that revolves around the marriage, which is the religious perspective. Now, there are n number of religions that surround the world with. However, we restrict ourselves here to a few. And if I begin to talk about them, in Christianity, homosexuality was not found in its very origin. That is evident because it is seen that an Eve was created for an Adam and not another Adam. However, in today's time, some churches do support the aspect of homosexuality and some don't. It's in Islam, they condemn the very aspect of homosexuality, and I quote, "Mithagun Galitun" is the term that they refer for marriages, which means a strong agreement. Marriage for them is for the purpose of legalization of sexual intercourse and procreation of children. Buddhism also does not refer to any special text. However, it seems that Gautam Buddha was very non-judgmental about the aspect of homosexuality, as the Tipitaka did not include any objections to the same if it did not include any arguments in the favor of it. However, in Judaism, Torah forbids the aspect of homosexuality, but what cannot be denied is that change is the law of nature. Evolution is our very being, and the Torah from the time of the Torah today, we've evolved. The Jews have evolved, and the Reconstructionists and the Reform movement have accepted the claims of homosexuality. However, the conservatives remain to be on the back seat of the same. Now, if we see about the Hindus, there was no specific and explicit mention of the recognition of same-sex marriages or the aspect of homosexuality. However, the Rig Veda includes certain scriptures. It includes certain scriptures that would highlight the aspect of sexual acts between women. The Hindus are deemed to be married by Saptapadi. The very mantra that is used in the same is actually gender specific and cannot be regarded for a man and a woman, thereby restricting the same. But the researcher at this juncture would like to point out that pertaining to the Hindu culture, the very fundamental document, which is the Bhagavad Gita, mentions that see, firstly, we know that marriage is the unification of souls. Bhagavad Gita mentions that soul has no gender, that there's no life beyond the soul or before the soul. Yet it does not include the aspect of homosexuality and includes all the aspects of gender in today's time. I'd like to point out to a verse that was used in Manu, which has been rephrased, and which reads that homosexuality is to be engaged and enjoyed for its own sake as one of the arts. Further, moving towards Stoicism, they regard health to be their 𝗕 They regard health to be above everything else, and most importantly, above sexual encounters. They regard that there has to be a balance in life and between the yin and the yang characters, that is the feminine and the masculine characters. Further moving towards atheism, believe in the gray. They deem whatever the deem is right, they believe in it. Thereafter, hence accepting the claim of homosexuality and same-sex marriages as well. But Sikhism does not seem to accept it, because they believe in the spiritual union only between a man and a woman. Now, moving to the next perspective that bounds the aspect of marriage, which is the sociological perspective, the researcher would like to strict here to certain points. The very first thing is that the aspect of homosexuality was regarded as unnatural or as a violation of the very violation of the very natural and the social order. However, what the researchers contend here is that it was not, from the very beginning, it was not the aspect of homosexuality. However, it started from the very discussion of sexual activities, which was not permitted, as also which was fueled by the atrocities that the people of the same sex involving the homosexual activities were subjected to when Aryans invaded in India. That is, it is the enigma and the threat that has been brought down through all these generations and still exists in the society. The second aspect that the researcher would like to point out is the very idea of parenthood and the want of the enigma of one's own blood to flow through progeny. The people are not really receptive of techniques, the modern day techniques like IVF and others that imposes that restricts themselves into accepting the complete aspects of homosexuality. Now, further, I'd also like to point out here that it is also against the Article 14 of the Indian Constitution, which has been granted to every citizen. Also, Article 15, which is a discrimination on the basis of gender. Also, it brings a resistance to change, which, I repeat, is the law of the nature, and it deals with the values of traditions and customs and social order. Now, the researcher would further like to move towards the legal perspective revolving around the aspect of marriage. Now, it has to be, at the very outset, it has to be brought to light that until today, there is no legislation, no statute, no specific law that deals with the aspect of same-sex marriages or of homosexuality in any manner whatsoever. However, if I talk about the legalization of same-sex marriage, the first instance can be noted in Netherlands in 2000, followed by Belgium and then Spain. Until date, around 29 countries have legalized same-sex marriage, with Costa Rica being the latest, which legalized same-sex marriage during the worldwide lockdown in 2020. Now, I'd like to point at this juncture, I'd like to point out what Justice Kennedy observed while legalizing same-sex marriages in USA in the case of 𝗷𝗫𝗄𝗏 versus Hodges, that marriage is the profoundest union of all. It revolves around itself with love, devotion, fidelity, family, and sacrifice. And to claim that marriage between homosexuals devoids the sanctity of marriage is in itself absurd and perverse. Now, if we further restrict ourselves to the Indian aspect of homosexuality, the struggle began around the late 20th century when there was
the time is up.
Okay, if the chair permits, can I have only 2 to 3 minutes more so that I can conclude?
Okay, ma'am, you can take 2 minutes.
Yes, please conclude.
Please conclude, sir.
Thank you so much. So the Indian aspect of homosexuality began in 1991 when some reports were highlighted, which highlighted the extortion and blackmail on the gay people. It led to the filing of a writ petition in 1994, which specifically wanted the availability of cost-free condoms to the inmates of the 𝗕 jail in Delhi. However, which was rejected because it was seemed that this would promote the idea of homosexuality. The struggle, the petition was dismissed thereafter in 2001. The struggle around the same began in as early as 2001, which was set to peace in 2018. The NAS Foundation became the first NGO that filed the PIL in 2001, which was at the first instance dismissed. Thereafter, an SLP was filed in 2006, which on the basis of public interest, which reinstated the court to the case to the Delhi High Court, which decriminalized Section 377, which was again overturned in 2013, and there was again another petition in 2016, which finally set the struggle to rest in 2018 by deeming Section 377 of the Indian Penal Code, which criminalized the homosexual acts as constitution and decriminalized with a unanimous verdict. At this juncture, it has to be noted that there is no legislation on same-sex marriages, even though the aspect of has been decriminalized. Also to bring the bench in light with the few changes that have been brought. Not legalizing same-sex marriages does not within itself per se stops the people from engaging in such acts, and in marrying. It as early as 1987 recorded the marriage of 2 policemen, and the lack of recognition certainly did not seem to have stopped them. Thereafter, in March 2018, Madras High Court March 2018, Supreme Court in 𝗖𝗣𝗄𝗏 versus Union of India held that an adult has fundamental rights to marry a person of their choice. The Madras High Court in 2019 recognized a marriage between a man and a transgender woman, and the Gurgaon Court in 2011 legalized a marriage of 2 women, Beena and Saraswati. Thereafter, the latest case can be noted down in January 2020, wherein 2 men from Kerala got married, becoming the first couple in Kerala to have married. There is also currently a petition pending in the Delhi High Court, which was filed for the very purpose of legalization of same-sex marriage, to which the Solicitor General of India, Mr. 𝗕𝗫𝗄𝗏 Mehta, had objected to. And however, it is still pending, and the last date of the case was 8th of January of 2021 only. Now, the last aspect that the researcher would just like to point out and conclude with is the effect of non-legalization of same-sex marriage on the inheritance laws. Now, it has to be noted that marriage is the social understanding of solemnization of conjugal views. The consequence of Hindu marriage follows with the creation of a Hindu undivided family and the very want of karta. It is parallel to the laws. It is not just a union between the souls engaging love and fidelity and family, but it is parallel to the laws of property, the laws of succession, the laws of the laws of inheritance, and the laws of legitimacy of the children being born out of such marriages, which of course is deemed to be the future of the country. Now, it has to be seen that to be subjected to the Hindu Succession Act, there has to be a Hindu joint family which is made by a common male ancestor, only required for its creation, not for its continuation. The question that the researcher brings here is, how will property be devolved to the heirs in such cases? The law seems to be silent on the same. I'd like to conclude by saying that potential existence of the LGBTQ community in the grey should be understood to be considered in the way that is preferential towards homosexuality, and with the want of need in the amendment, which is the need of the hour, with the removal of the social stigma, the social enigma, and the gigantic political affirmative view with the orthodoxical and the conservative nature of the society. Thank you so much.
Thank you so much, ma'am. Rakesh sir, Kanwal ma'am. Kanwal ma'am.
Yeah. Tanya, I have a question.
Yes, ma'am.
So you concluded with many ideas, but can you give some concrete suggestions what you think can be done?
Definitely, ma'am. Ma'am, in the recent case that is pending in the Supreme Court of that is pending in the Delhi High Court, it was pointed out that Mr. 𝗙𝗵𝗃𝗄𝗏 pointed out that such cases cannot be brought to the judiciary because the change has to be brought from the legislature. Right. So what the researchers
say that not legislature, not judiciary, it is for the society that has to create an acceptance then?
Ma'am, the society, what I'd like to say here is that the society is evolving in its very self. Today, there are more than 2.5 million people in India that claim themselves to be a part of the LGBTQ community, which according to the researcher, the numbers according to the researcher are deemed to be a start somewhere. If the legislature brings a push, these 2.5 million people will claim themselves within the community and will bring a change into the society further. Also, to answer your first question, ma'am, I'd like to say that that throughout there are debates and that there needs to be a change in the Hindu Succession Act or the Hindu Marriage Act or the Special Marriage Acts for that matter. However, what the researcher personally believes is that there would be n number of amendments required for this matter. But we also know that where there's a specific legislation with respect to the same, that is given resort to. What the suggestion that the researcher would like to give forward is that a special legislation for the marriages of people of the same sex should be brought in light, and which will limit the requirement of amendments to the Hindu Succession Act, the Hindu Marriage Act, the Special Marriage Act, or even the Foreign Marriage Act for that matter, and would only require an amendment in those acts which direct such people, which direct the marriage between a man and a man, or a woman and a woman, or people of the LGBTQ community amongst each other to the new legislation, and not towards the Hindu Marriage Act or the Special Marriage Act. Thank you.
Okay, sir, would you like to ask anything?
Rakeshji, if you have any questions from Tanya.
Anya, you presented it well, and see, but still I am not convinced. You have to substantiate your claim through some ideas. I don't know, but you have not substantiated what you are saying.
Ma'am, if can I please try to build that in a minute?
Yeah.
So, ma'am, I'd like to say that what suggestions that can be brought forward by substantiating with the various cases that the Madras High Court, the Delhi High Court, and then the Supreme Court of India has brought is that marriage is the right of personal liberty and a fundamental right granted to every citizen, which has to be upheld in any manner. Even not legalization of marriage is creating a void in the society, because people are anyway getting married. They're anyway getting married even though it's not being registered. That creates a question of property, that creates a question of legitimacy of children, right? So that question needs to be addressed. What the researcher is trying to bring forward is that there is a need of a special legislation in light of all the judicial pronouncements that have been laid till date, that recognizes that it is the very purview of Article 21 that a person can marry whoever that they want to, irrespective of the gender, and the statute should lay importance to the laws of inheritance, to the laws of legitimacy of children, and to the registration of the marriages between same sex as well. Now, more legal, why they cannot be more legal backgrounds the same is because India till date has no legal structure and no legal text in any manner whatsoever revolving around the aspect of same-sex marriages. However, regard has to be given to the judicial opinion, which has been consistent since time and again, and in favor of legalization of same-sex marriages and in favor of the homosexual acts per se.
Okay, thank you, Tanya.
Ma'am, I'd like to just add one more point. Is that since India is a developing country and we all deem to be marching towards the economic enhancement and of the country, there's another point of consideration is that people in India, the homosexual people in India, go outside the country to get married, which certainly somehow affects the economic considerations, the social considerations of the country, which also will be given importance to once the issue has been properly addressed. Thank you.
Ma'am, sorry to interject, but I have a point to make. Ma'am, actually, under the Special Marriage Act, the definition points out that, marriage between two persons. So that can be interpreted in the favor of,
yes,
same-sex
yes,
marriage.
Thank you for bringing that to light. What I'd like to say in contrast to the same is the Special Marriage Act definitely mentions that marriage between two persons. However, the same is not recognized. I'd like to bring a very recent case to that. Is in 2019 in UP, two women got married and went to the registrar to register their marriage under the Special Marriage Act. However, the registrar rejected their claim and said that there is no legal backing of the same. Now, even though Special Marriage Act mentions that marriage can be between two persons, yet it is because of no legal backing that there is a fear and amongst the authorities within on their shoulders themselves, which permits them and restricts them in walking towards that. There is no legal exception towards that, and the present case that is pending in the Delhi High Court, the writ petition, particularly deals with the aspect of inclusion of same-sex marriage in the Special Marriage Act in itself.
Okay, thank you so much, ma'am. Rakesh sir, would you like to ask anything?
ठीक है.
मैम जल्दी जवाब बताना है तो FB लाइव चल रहा है.
Sorry, sir.
Now,
sorry.
We are moving very progressively, and so many thing is being carried out. Now the living relationship is being recognized, adultery is being now legalized. How you foresee the Indian society 20-30 years down the line?
All right. So how I foresee Indian society 20 to 30 years down the line is obviously in a progressive manner. Today, as I said earlier, there are more than 2.5 million people in India who regard themselves to be coming under the LGBTQ community. Once, even in a decade, if a special legislation, a special statute has been passed with respect to the same, there'll be more and more people coming within its ambit. There'll be also, if I give an international importance to the same, then the country, India per se, has been restricted as a nation by not seeing a progressive development in the same. However, once the same is passed, it will come in line with the odd 30 countries, especially in the very developed nations of Europe and America, and will also be in line with many other factors like the flow of like the stopping the flow of the very resource that people are to the country that flows outside because the laws do not permit them to live here. So that firstly restricts the resource that the country could very well use. It is what I see is economic development along with the social development and the psychological development of the same. As I said earlier, evolution, change is the law of nature. We're all subjected to evolution. And 20 to 30 years down the line, the entire scenario has to be evolved. It was only 20 to 30 years before when the first writ petition was filed in 1994 in the Delhi High Court for with aspect to the section 377, and by today I think we've taken the first step of decriminalizing the homosexual acts. However, the first step need not be the last. We have to keep walking and walking in the same. Thank you, sir.
Thank you, Tanya.
Is there any other question that the researcher can address the bench with?
No, thank you so much.
Thank you, Tanya. Okay, thank you, ma'am. Thank you, sir. I will love to thank all the presenters who have presented today for sharing their valuable insight and the knowledge. I want to welcome again Dr. Rakesh as associate. He is the associate professor, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. His total expertise is more than 15 years in academics, and his area of interest is constitutional law, income tax law, and election law. So I welcome you. So you want to say something? Highlight this.
Once all right, ma'am has already comprehended the entire things, but it's very good that you have chosen a very contemporary issue regarding the family law and the emerging challenges. And in this, the researcher has also tried to address some of the emerging area of the family law, because if you see the our societal setup, here the women are being subjected to various kind of violence, exploitations, humiliations, that is from the time immemorials. And it is not something which is only after the arrival of the Mughals, then from medieval time, the entire thing has changed considerably. If we read our ancient texts, then when I was in school, then I used to read that the Yatra Nadi Pujyante Ramante Tatra Devta. So this was the concept, this was the Indian philosophy. But because of the economic deprivations, because of the patriarchal setup, because of the way the society has moved, here the women has been gradually pushed towards the kind of the subordinate positions, and the various kind of the social level has emerged regarding the dowry, then the infanticides, sati, then widow. So there are so many things, and including that there has been constant effort to deprive the women of the basic right to the property. So these are the something. In case of the dowry also, you can also find that everyone thinking that the bride is the gold mines, and if they turn out to be otherwise, in that case they are considered as a combustible material. So it's kind of the mindset which actually required to be changed. There has to be conscientious the efforts on the part of the society. There has to be awakening on the social consciousness. So only in that case, the lot of the women can change the society. If we continue in this way, if the piecemeal legislation is being carried out, or if the judiciary are coming out with some kind of, this is not something which is going to address the entire issue in the holistic manner. So naturally, these things needs to be addressed, and there has to be efforts on the part of the legislature, on the part of the policy planners, and the judiciary also has to contribute. If you see the approach of judiciary also, it is not always it is recently the judiciary has reflected their keen biasness towards improving the lot of the women. But if you find so many cases like 𝗏𝗏 case, where you can simply ascertain the male bias on the part of the Supreme Court, because in that case the regulations 34, 35 was being challenged. That court says that if women get married at the later stage, then every possibility of the marriage will be successful. So this kind of approach you cannot altogether negate. But anyhow, there was good efforts on the part of all the research scholars. Some of them has sincerely worked very hard. They have tried to put the maximum footnotings. There was also, they have highlighted how the law is deficient in the certain aspects. So anyhow, it's a good beginning, and CPJ continue, and then some effort is being made regarding the editing work. Because if some articles are not up to date, in that case, I think there is no harm in rejecting those articles where they're just going for the cut and paste and they're submitting it. I think this is all. I'm handing over to Kamal ma'am.
Thank you, Rakesh. You've nicely summed up everything. And I congratulate everybody for the effort that they've put in. And it was a very good effort that the conference that was pending from 2020 March, we were finally able to hold it and hold it successfully. Congratulations to everybody. Thank you.
Thank you so much, sir. Thank you so much, ma'am.
You answered.
Thank you so much, sir. Thank you so much, ma'am. Now I will again, on the behalf of CPJ College of Higher Studies and School of Law, would like to express my deepest gratitude towards Dr. 𝗔𝗿𝗄𝗏 and Dr. Rakesh for giving their valuable time. I would also like to thank all the presenters for presenting their studies on this forum. Thank you everyone for your valuable time and effort. Now technical session 2 has been over. Now we are further moving on for the validatory session, and there it will be announced the best paper award will be taking place. Over to you, Garima ma'am.
Thank you, Shmeet ma'am, and thank you to all the presenters and guests. The family laws are in practice to ensure and enforce the human rights equally to all members of society. Since the societies are formed through family units, the quality of life among these units is significant to be maintained. An awareness and understanding of the family laws can help people to avoid chaotic situations in their daily lives and ensure a better peaceful living in the society. Considering the theme of the National Conference, which is Family Law, Contemporary Challenges and Solutions, we have listened to the eminent speakers in different 2 technical sessions who deliberated on the theme with a wider scope. Now it's time for a validatory session for the 5th National Conference of CPJ College of Higher Studies and School of Law. And I feel great, it feels great pleasure and honor to welcome our distinguished guest, Dr. 𝗂𝗏𝗄𝗏 as our guest for a validatory session. Ma'am, CPJ welcome you again wholeheartedly.
Thank you so much.
I would also like to welcome Professor Dr. Rakesh, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University, Dr. 𝗏𝗏 𝗂𝗏, Assistant Professor, University School of Law and Legal Studies, Guru Gobind Singh Indraprastha University. Thank you, sir and ma'am, for gracing our national conference as our keynote speakers in the session chair for our technical sessions. We are also privileged with the presence of Mr. Yuganksh Chaturvedi, Director Journal, Dr. Amit Jain, Deputy Director, School of Law, and Dr. Shalini Tyagi, Dean, School of Law. I once again welcome you all wholeheartedly for the validatory session of our 5th National Conference of CPJ School of Law. Indeed, it's our honor with the presence of Dr. 𝗂𝗏𝗏𝗄𝗏 to grace the validatory session as our honorary guest. Ma'am has started her career as a lecturer in Amity School of Law in the year 1999, and in 2008 she was promoted as professor and deputy director and transferred to Amity University. Ma'am has a teaching and research experience of more than 14 years, and she has completed her PhD from Jamia Millia Islamia in 2007. Her specialization includes capital market and land laws, and she joined the University School of Law and Legal Studies in May 21, 2013. It's my honor to invite Dr. 𝗂𝗏𝗏𝗄𝗏 to kindly give the inaugural address for the validatory session, please. Over to you, ma'am.
Thank you, Garima, for your kind words. Mr. Yuganksh Chaturvedi, Dr. Amit Jain, Dr. Shalini, ladies and gentlemen, my faculty colleagues, and most of all, my dear students. I'm honored to join you today at the validation of this National Conference on Family Laws. And I'm glad to see that this is an opportunity where many of us have had a chance to share our thoughts and experiences and the issues which I think all of us are passionate about. In this conference, we could see practitioners, we could see teachers, we could see people who are working for the community. And among so much of diversity, there was one constant, that we are all partners who care for our families, and especially in these times of uncertainty and crisis. I'm sure we all share the same heartache when we see the families embroiled in disputes and moving to the court of law. And we see that our children also become embroiled in this tussle and our family values are left behind. Against this backdrop of COVID times, let me state categorically that we as a society have a duty to support our families. Families are the building block of the society, and a stable society can only function when the families are functioning as a unit and we are caring about each other. I will like to elaborate this thing on 3 parts. First and foremost steps that we need to take is that we need to have upstream preventive efforts. Preventive efforts for what? To do away with the lines that are drawn between the families, to break the cycles, and to keep the families intact. We also need to look into it that we partner together to work towards good healthcare, a strong society, good education sector, so that the families can use opportunities and the government and the common man partners and sees that the families have strong ties. The second thing that I want to stress upon is that the times are changing. The forms of family, the norms in the families are changing. So we need to have an idea of what are the new challenges that are coming about, and the solutions have to be found out against the new normal and against the new developments that are taking place. With the transnational marriages coming up, with the cross-cultural marriages taking place, we have to manage the families very differently in the times of cultural differences. We have to review our policies, programs, and we need to better support them. And unfortunately, we can also see that when divorces are on a rise, we need to mitigate the challenges by acting early to support the families so that they build up strong bonds and they stay together. And whenever a family is in a tussle, we need to compassionately work with them, and our approach has not to be dictating or to be preaching. It has to be compassionate. Finally, the third thing that I need to say is that we have to be future ready. If there are so many changes now, the society will change more fast in future. We have to make ourselves ready, and we have to be prepared for the emerging trend. Like one thing that I can quote is that the families are shrinking. There are not many people to take care. There are smaller families that are coming up. So we need to be prepared to take care of the aged in our families as for the times to come. We need to support them, and we have to empower our social system to organize a protective care for the families, and the social system needs to be tested that whether it is ready to face the challenges that we will see in future. Not to say that we are not making different strides towards this common objective. We have good legislations, we have family intervention services, we have many things, many NGOs and many community programs that are working towards dealing with families. We are developing strong partnerships within our network, but we need to encourage it. We need to encourage what is right, and we need to see that it is done in the best way that is best for our society. Indian society is diverse and different, and we need to see and find out legislations or the systems that work best for our local systems. We must enhance our social system, and we should commit to bring the roots of our old teachers into the society and see that we follow the old preachings of our saints and gurus, and on the other side, we approach whatever changes we are taking and we see that we assimilate them in a better way. We should, with each passing day, we should empower our families and see that they work together and stay together. Thank you.
Thank you, ma'am, for sharing your words of knowledge with all of us. The award provides an opportunity for all players, empires, and teams to be recognized, and one of the key strengths of the system we have in place is that this recognition comes from respected voices within the game. On this note, it's time to announce the Best Paper Award for Technical Session 1 and 2. For that, I request Dr. Kavaldeep Singh, ma'am, to kindly do the honors, please. So, ma'am, the Best Paper Award for Technical Session 1 goes to...
Garima, I do not have the list. I have only the list for Technical Session 2.
Okay.
If you could just tell Shalini to WhatsApp it to me, I'll announce it.
Yeah, surely, ma'am.
Session 2, not for the Technical Session 1.
Surely, ma'am. Surely, I'll just communicate that Shalini, ma'am, to kindly, give you the name. Meanwhile, I request our mentor, Yogong sir, to kindly, address the gathering with his words of wisdom, please. I'll communicate. Meanwhile, I'll communicate with the team.
Yeah, thanks, Garima, and welcome once again, Kamal ma'am and Dr. Rakesh. As it's saying, it's a norm of the world. You wish for something, you wait for something, and the time is the biggest factor. It goes on, and of course, what was all the apprehensions in the morning at 10, at 4 p.m. in the evening today, we are very content and satisfied with the field. There's a 5th National Conference which we were to hold online because of the COVID has gone off pretty well. No two doubts about it. A lot of things that have been shared. And as Dr. Mehra, Dr. 𝗏𝗍𝗄𝗏 Mehra in the morning in the inaugural address, and the Kamal ma'am also did impress upon it, that of course, as our conference was to be held in March 2020, but because of COVID, it got deferred. but no two doubts, not just me or any and everybody present in the forum as of now, but I suppose the world over, because this was the first pandemic in human history to have hit the world over, like which did not spare any continent or any place, any country, in fact. Very first kind of a pandemic that way. So one thing which I would feel that the world over, which was felt very strongly by one and all, that family in itself and by itself is a very, very strong unit. I suppose in these times of COVID, when we were landlocked, when we were absolutely house locked rather, no two doubts what all trauma we all went through. But I suppose it was the support of one family member to the other, one to the another, that which led anyone and everyone to, kind of go through it, sustain to it, and come victorious out of it. No two doubts, today's paper presentations, they did cover a lot of what you call sub-themes of your family law, the main theme, which included papers on uniform civil code, the transgender, the domestic violence, Hindu united family, surrogacy, live-in relationships, same-sex marriages, and some others too. So what I believe in this is that wherever the presenters have tried their best to put their thoughts across, the researchers, their work, whatever they are going through in their research projects, they have been able to put it across. Somewhere, as Rakesh ji said, Kanwal ma'am did impress upon in the first technical session, Dr. 𝗂𝗏 𝗏𝗀𝗏 and Dr. Anuj Vaksha impressed upon that some papers were very much targeted, wherein they had in their conclusions, they had the way-outs also for the questions that they posed. This is very important. Not just posing question is a part of presenting. With posing question, you should have certain answers which be at the back of your mind, that how that can be worked upon. And this is what Kanwal ma'am also said very recently while addressing one or two presenters, and Rakesh ji also said. So I totally stand with them on this. But more or less, I would say that most of the papers, they were very much there with good content. And of course, I wish the best to all the presenters. I'll come back again. In the meantime, thank you once again, all of you. And formally, I would be thanking you all after the valedictory, the award winning address to be given by Kanwal ma'am. Yeah, over to you, Garima, please. Yeah.
Thank you, sir. Thank you for sharing your words of wisdom with all of us. Now I request Dr. Kanwal Singh ma'am to do the honors and let us know the best paper award for the technical session 1. And the winner is?
By the Dean Shalini that the technical session 1, the best paper award goes to Ms. Ghazala Abidin.
Okay. Congratulations.
Hindu undivided family and taxation. That was her topic. And I'm really happy. And the second technical section, the award goes to Mr. 𝗕𝗏𝗄𝗏.
Oh, that's good.
He is on transgender. And Mr. Yugang Chaturvedi, I would like to share one thing with you today. And I'm very happy to share that when I was judging the technical session 2, I had told Dr. Rakesh Kumar that I will recluse myself because Vinayak is my scholar.
Ma'am, I have just gone through all the articles. I have just focused on the technical aspect, that who is coming out with the well footnotings and how they are just putting across the emerging areas. And in this article, there was Tanya was also very strong contender, but the Vinayak has having a bit of edge because he had just tried to enlarge the things. Because the Radhakrishnan's pragmatic view was somehow being overshadowed by the Justice Sikri. So he again tried to assert those broader ideas. So that's why the Vinayak is rightly deserves to be
I want to add one
toppers of the second technical section.
I'm very proud to be here today because Ghazala is also my student. Both of them are my favorite who won the award, and I'm really proud of them.
Excellent.
Thank you, sir. Thank
First
you, ma'am.
technical section I was there, and to hear her name, I'm really happy. Though technical section 2, I was myself present, but I'm very happy that both my scholars have won the award. Thank you so much. And
I would like Dr. 𝗂𝗏 also to speak something here. Since Dr. 𝗂𝗏, you are very much here, please.
Yeah.
Dr. 𝗂𝗏.
You'll have to unmute. You'll have to unmute yourself, ma'am. Yeah.
Yes, as I told in the earlier session also that Ghazala, at the topic which was selected by Ghazala and the way she wrote the paper, and it was a learning experience for me also because I also learned from the paper, and rest the other papers were also good, but the case laws which were cited and the manner in which the citation was done, footnoting was done, the reference was made, I think that paper was much ahead in those respects, and was following a correct methodology, as in clearly categorizing the hypothesis, then the observations, and then yes, she was very, the paper was having a lot of clarity in itself, and something that was new to me as well, to this thing. So that is why she deserves the best, though other papers were also good, but then yes, as I said earlier, it was a learning experience because none of the paper were overlapping. It was not that on one topic I was judging two papers or something like that. Yes, every paper was unique in itself.
Every paper was very different, and they have chosen papers in a well organized manner.
Yes.
And I congratulate Ghazala and Vinayak. Congratulations. Ghazala is not here.
Thank you, ma'am.
Ghazala, you have to unmute yourself.
Okay.
Congratulations to the winners, and the winners has been also awarded with a cash voucher of ₹5,000 from CPJ College of Higher Studies and School of Law as a token of gratitude from our team. And I again wanted to thank Dr. Kanwal Singh, Dr. Upma Gautam, and Dr. Rakesh Kumarji for being with us and for sharing your knowledge with all of us. In the end, a mentor empowers a person to see a possible future and believe it can be obtained. He always inspires everyone to do better. Ladies and gentlemen, on this note, I would like to invite the mentor of CPJ College of Higher Studies and School of Law, who always guided us and motivate us in all the prospects. Let's welcome Mr. 𝗂𝗂𝗄𝗏 𝗔𝗏, Director General, to give the concluding remarks for the valedictory session of National Conference. Over to you, sir.
I request गरिमा जी, इनको जो दोनों हमारे winners हैं, इनसे भी experience लीजिएगा.
Yes, sir. The interview will take place after the valedictory session.
So you can, Miss Ghazala, since she has unmuted herself,
yes,
let
sir.
us hear from her, and Vinayak can also be made to unmute, and we can hear something from him as well, please. Yeah.
Absolutely, sir.
Yeah, I would like to thank CPJ, and my special thanks to Professor 𝗂𝗏 because she is the real source of inspiration. Because Kanwal ma'am, I don't think that it would have been possible. So she's the real source of inspiration for me. Seriously.
Ghazala, tell the true thing that
yes,
you never wanted to study taxation.
Yes, ma'am. True. Absolutely true.
Congratulations. I'm
Thank
very
you so
happy.
much, ma'am. Thank you, ma'am.
Mr. Vinayak would like to say something.
Yes, sir. Absolutely,
yes.
sir. So the only
Vinayak,
thing
sir, please turn on your video.
Oh, sorry. Yes, sir. Yes, ma'am. The only thing I would like to say is that, during the continuance of my presentation, I have always, this habit of reinstating things again and again. And I would actually give my credit to, of course, my supervisor. There's no doubt on that. But the second credit would definitely go to Rakesh, sir, because the kind of question, see, sir, I am that sort of a person who likes grilling. So if you grill me, I'll be, I'll come up with a better sort of explanation. I'll try to come up. I'm not sure whether it will be better or not, but I'll try to come up. So that keeps the momentum going. So this is what works for me. That is like the apt situation for me. If you grill me, I'll be happy
inviting trouble for yourself.
Yes.
No problem. I will wait for you in law school.
Yes, sir. So thank you, ma'am. Thank you, sir. And thank you to all the dignitaries who actually, gave us the platform. Thank you, everyone.
That's one more, outcome of this is that Dr. Rakesh is pretty good at grilling. So that's also a piece of information. Yeah.
तो family law से मेरा area नहीं है बस.
जी.
ऊपर से देख लिया था.
जी. Yes, Karima, please.
So I request 𝗂𝗂𝗄𝗏 sir to kindly give the concluding remarks for the valedictory session of National Conference, please.
Yeah, thank you, Miss Garima. Thanks so much. And thanks all the guest today, the honorary guest. We had Dr. 𝗖𝗵𝗃𝗄𝗏 𝗦𝗃𝗄𝗏 in the morning as our inaugural speaker for the inaugural ceremony. And she had to go to Shimla in the second half, so she must be on her way as of now. That's why she's not been able to join the valedictory. Otherwise, she had all the intentions to. My thanks to her. My thanks to Dr. Anuj and Dr. Upma for being the keynote speaker and session chair for the technical session 1. Your association with CPJ, it's always been a great one, and I look forward to your association for all coming times, please. Thanks again, Kanwal ma'am and Rakesh ji. No two doubts, the same goes with you. I always have considered some people as part of my family, not just the CPJ family. We consider it as an extended family, and you being very senior and very important members to that. And it's always a great feeling to be there amongst you, between you, and to hear you. No two doubts about the same. When I am putting my words of thanks, no two doubts, thanks to the delegates, all the participants. I must say that it's very difficult to kind of gauge who's the better one and, coming out with the best paper award in the finale, because there are always 2-3 which, have a very good clash about the same. But as I've always quoted, that if you've seen the 100 meters race of an Olympics, who would not, debate, who would rather debate on this fact that all those 10 guys are the best sprinters in the world, but finally it's one who gets the gold, it's another who gets the silver, and one the bronze. So like it's a photo finish there. So they all sprinted to their best that day. Same way, you all gave your best views, your best papers, your best presentations, but out of it, naturally, the judges, our session chair, our keynote speakers, they were able to gauge it. And my congratulations to 𝗏𝗏, Ms. Ghazala Abidin for being the best paper, bagging the best paper award for technical session 1, and Mr. Vinayak Jham for the technical session 2. And of course, my congratulations to Dr. Kamaldeep Singh ma'am, that you have mentored both of them. And it must be a day of good pleasure for you. Make feel confidence, feel, yeah, you're mentoring in just the right directions. Yeah. So along with this, I would always love to thank Dr. Abhishek Jain, our management, from the management, because he's always stood rather as absolutely as a pillar next to us for supporting all such academic activities and to let them go and to make CPJ a proud place to be in for academic learning. All my thanks to all the faculties and the coordination committee member of this national conference who really worked pretty hard, Ms. Sukanya, Ms. Nisha, and others who really worked pretty hard. We had Ms. Mansi, Ms. Arpita, Dr. Shalini, Ms. Preeti Goyal, who really worked very hard towards all these things to happen. Thanks to Dr. Amit Jain for doing a very close coordination and of course remaining very intact when it comes to the publishing of the proceedings in such a small time. You did a great job, Dr. Amit, in doing so. And we are proud to have the proceedings before the conference and made sure that all the guests of ours, they get a copy of the same before the conference happens. And my thanks to the technical staff of CPJ College, which enabled during these turmoil times also, since CPJ College is next to the border, the Singhu border, which is very much under a lot of turmoil these days. So, the network of that area keeps getting perturbed in between. There's a lot of disturbances, and we were quite apprehensive about it, that today's national conference, how would it go absolutely, that there's no technical glitch. And touch wood, it has happened that way. My congratulations to the technical team, to the social media team for all their support and everything that went. It did go as it was anticipated to go that smooth, that as we thought it to be, and it has really gone the same way. My thanks all over again to all of you, all the students too, who have very patiently gone through today's conference. And I'm dead sure about the fact they would have learned a lot out of it. And these pieces of learning which should get embedded into you. This is the time for you for learning, and all these things which will get into you. This is like information being fed into a computer, into a laptop, and only what is fed comes out. Nothing out of the blue pops out of it. So whatever you'll put here, only would remain with you and you're able to dig it out at any point of time where it is really required to. So thanks again. And thank you so much, I must say. Thanks, Kamal ma'am. Thanks, Dr. Rakesh. Thanks, 𝗂𝗏𝗪. It's been always a grand pleasure.
Thank you so much.
A great pleasure. Yeah, thank you so much. Over to Garima, please.
Okay, sir.
Thank you, sir, for sharing your words of wisdom with all of us. Before concluding, I would like to request all the delegates and the winners of technical session 2 in 1, along with our guests, to kindly give us the interview bite after the validatory session. The delegates, the link will be shared with you in the official WhatsApp group of National Conference. And for the guests, the link will be shared by our resource person personally on their WhatsApp. I'll be concluding the 5th National Conference of CPJ School of Law by saying the famous lines of Martin Luther King Jr. I quote, "We need leaders not in love with money, but in love with justice. Not in love with publicity, but in love with humanity." So let's become the leaders of humanity and stay on the path of justice with love and respect of others. On this note, I would like to thank all the guests and the speakers for giving their precious time to CPJ College of Higher Studies and School of Law for the National Conference. I want to thank the technical team for being with us whole day and for the smooth functioning of our National Conference. Lastly, but not the least, I would like to thank whole National Conference organizing team for the grand success of our 5th National Conference. Thank you, everyone, and hope you have a nice evening and a weekend ahead. Thank you, everyone. Thank you so much.
Thank you. Thank you so much. Yeah.
Thank you, sir. Thank you.
Thank you so much.
Thank you,
Thanks,
everyone.
Rakesh. Thanks, Kamalji. Thank you so much. Right, 𝗂𝗏𝗪.